Number one. Item number two.
Attorney Lordship, I am for the petitioner on behalf of Mr. Lokinath Bharja. Kindly pass over the matter, Lordship. Is engaged in code number 39, Lordship.
Not today.
Great, Lordship.
Number three. And it is appearing mallet is coming with my senior. Let me start from scratch.
Still Almighty Union of India. সবাইকে দিয়েছে সুপ্রিম কোর্ট অব্দি ইয়ে হয়ে যাবে। সবচেয়ে এইটুকু বুঝলাম।
Yes.
Basically, I don't remember. I have submitted more or less the factual score. Thing is, this is basically, my lord, reduction or the withdrawal of the benefit of MACP. The
Benefit of
MACP, my lord.
MSCP.
MACP.
MSCP granted in which year?
The MACP granted initially, my lord, higher scale of pay was given, my lord, with effect from notional benefit, my lord, with effect from, my lord, 9/8/99.
No. Who are you? What post you are holding?
We were, my lord, initially as, my lord, time scale postal assistant.
Yes.
We got ourselves transferred, my lord, to the another wing of the postal department. Then, my lord, our pay was
When were you transferred?
my lord, during the year 1992.
1992.
1992. Well, diverse dates. So many petitioners are there. And here, my lord, one thing at the outset I should submit, all the petitioners by now have retired from service.
Very well.
Now, my lord, when such transfer was made, my lord, their scale was fixed. My lord,
So when they went in the other wing, they were still designated as TSPA.
no. Subsequently, my lord, a promotion was given.
When they went in the other wing, what was their designation?
LDC, my lord.
LDC.
LDC.
So in LDC, they were placed in which pay?
They were placed, my lord, 975, 1660.
Yes.
Then, my lord, they got promotion, my lord, to the post of junior accountant. Junior accountant.
Yes.
The fourth CPC scale was, my lord, 1200 to 2040 / my lord, 4000 to 6000. Now, what happened, my lord? The scale of entry cadre.
This promotion to junior accountant in which year?
During the period, my lord, 93 to 96.
All of them.
All of them on diverse date, my lord.
Very well.
Now, my lord, in the meantime, what happened? The scale of the petitioners, my lord, at the entry cadre, that is TSPA, and the scale of pay of junior accountant, my lord, were fixed at one pay scale. That is 4000 to 6000, my lord, with effect from, my lord, 1/1/96.
So the earlier post and the post of junior accountant.
It was merged, my lord, in view of the fourth pay commission's recommendations, my lord. It was
in view of
the pay commission's recommendation, my lord. Those pays were merged, my lord, and identical scale of pay. Meaning thereby, my lord, they
effect from 1/1/96.
Yes, my lord, 1/1/96. They literally, my lord, did not get any benefit of promotion. Then, under such circumstances, my lord, the higher scale of pay of first financial upgradation under ACP scheme was given as 5000 to 8000 with effect from 9/8/99, ignoring that, my lord, paper promotion.
Where is a paper promotion?
Yes, paper promotion means, my lord, that the promotion to the post of junior accountant. The scale of pay of junior accountant as that and that of, my lord, TSPA became same.
No, but that became same subsequently.
No,
At the time you were posted in 93.
Yes, my lord.
It was a higher scale.
Now you will also kindly appreciate that benefit with effect from 1996 was not practically given. It was given a subsequent with effect on a subsequent date.
No, you just now you said with effect from 1/1/96.
Yes, it is notionally, madam.
Yes.
And you will also kindly see This benefit was also with effect from 1196. The revised or upgradation or my lord, the after fourth pay commission, this pay of rupees 5,000 to 8,000 was also my lord.
No, this is in 99. This is much later.
Yes, this is in
much-
99. But my
yes.
lord, thing is,
Until now, what you have argued, that after coming into the other wing
yes,
in 92, you were promoted as junior accountant in between 93 to 90 to 93.
yes.
No,
Lordship, I have handed over a paper.
93 to 96.
Yes.
No, that paper is as good as a new petition. Why you have given
Not as-
such an
not-
elaborate?
No, this is my lord. You also can see not as good as new petition.
The one you have filed, we are looking at that. Just see
Yes, your lordship.
paragraphs and paragraphs and paragraphs.
No,
That does not help much.
No, it's my lord, I have
No, no, just tell us what we are asking you, please.
Yes,
So 93 to 96, you were promoted as junior accountant.
yes,
You say that was in the scale of 1200 to 2040, revised 4000 to 6000.
yes,
Then you say in first ACP granted in 99. That was placing you in 5000 to 8000.
yes.
That was the next higher scale.
Yes.
So now, what after that?
Now, my lord, this scale was there. Thereafter, my lord, the first ACP was granted. My lord,
9899, that you have already said.
99,
Yes.
99, my lord. Then, my lord, the my lord, actual benefit of the scale of pay of rupees 4,000, 6,000, my lord, as my lord, my lord, LDC, my lord, was they did not get because the scale of junior accountant and my lord that of the LDC were fixed at same scale with effect from 1196. 1196.
We are not clear, sir.
Your lordship will kindly see.
You told us that from junior accountant you were promoted. From LDC you were
My lord,
promoted.
that's why the handwritten statement I have given.
From LDC you were promoted as junior accountant.
Yes.
In between
And
93 to 96.
all of them, your lordship will find that such benefit of 4,000 to 6,000 was given from 1796, 1197, 1196, 1196, 1196. All these, my lord, and rest of them are, my lord, on the earlier scale. So basically, my lord, when the pay scale of 4,000 to 6,000 were merged, my lord, and made identical to that of the junior accountant and LDC, they literally did not get any benefit, financial benefit. They have been actually given the benefit with effect from 1196, but it has been given to them on these dates. That I have given the statements. Because these statements was not there in the petition, my lord, I must admit that.
We are not going to consider anything which was not in the record.
No, it is
Nothing.
not there. I have stated, my lord, that
Sir, be very clear. We are not going to consider a sheet of paper which was not in the records.
no, my lord, I have just made a note.
You may give, but we are expressing very clearly we will not take into consideration the material which was not
Now-
on record.
Now you will also kindly see.
Yes.
After that, my lord, 4,000 introduction of 4,000, 6,000 scale. With effect
After
from-
what we are not following. You are going back and forth. You have given us a sequence of events. 1992 TSPA you transfer to the other wing.
Yes.
There the LDC you are getting 975 to 1660. 93 to 96 all promoted to junior accountant. Scale of 1200 to 2040. Then you say with effect from 1196.
That my lord, 4,000 to 6,000 scale.
Yes.
That was given, my lord, to the petitioners with effect from 1796 onwards.
With effect from 1796.
1796 onwards.
All right.
And my lord, the scale of
So therefore you got the higher scale, but you got it from 1796.
1796.
Yes.
So thereby, my lord, since the scale of junior accountant and as that of my lord the LDC became identical with effect from 1196, meaning thereby, my lord, the benefit of promotion in a higher scale of pay, I did not get
No. How does that mean that?
Well, it
You
means
are placed in a higher scale since the lower scale has now merged. Therefore, you are
Yes.
not giving
No,
any benefit.
yes.
How can that be that
I sell the
you have got the benefit? The lower scale has merged into this. That does not mean that you didn't get any
but
benefit.
I shall place, my lord. What
Yes.
are the clarifications? I shall
Yes.
place it. I shall place it, my lord, and I shall place the judgments also.
Yes.
The principles of MACP or ACP is that, my lord, that when the such scales become identical, ignoring that paper promotion or the promotion by which no financial benefit practically has been derived in view of such upgrades.
You are presupposing that no financial benefit was granted to you,
Yes,
whereas
yes.
the financial benefit was granted to you from the earlier scale of 4,000 to 6,000. You were from 975 to 1660. You were placed in 1200 to 2040.
Yes.
So there is not a. It's not a case of
1200 to 2040 is in respect of third CPC. On third CPC. My lord, then your lordship will kindly see. Now, my lord, your lordship kindly.
of CPC. That was the scale of the higher post of junior accountant. That is not as a result of CPC.
As a result of CPC, I shall place, my lord, the documents, the annexures, I shall place.
Yes.
I shall place. Your lordship kindly go through a little bit further. Then, my lord, since the fourth CPC merged the scale of pay of TSPA and junior accountant, introducing new scale of 4,000 to 6,000, the petitioners practically did not get any benefit of promotion. In such view of the matter, a higher scale of pay of rupees 5,000 to 8,000 was granted with effect from 9/8/99. Well, kindly take it on 9/8/99.
That is the first ACP that was granted to you. 9/8/99 is your first ACP.
Yes.
You have already told us up to this point.
Yes. Then what happened? That's why I am submitting. Your lordship kindly allow me to proceed further. Then the situation will become clear. Subsequently, the pay scale of junior accountant was upgraded from 4,000, 6,000 to 4,500 to 7,000 at a subsequent stage. That will appear from page, my lord, 69, 70.
4,500 to
7,000. And that the pay scale of senior accountant was upgraded from 5,000 to 8,000 to 5,500 to 9,000. Notionally with effect from 1/1/96, with actual benefit from 19/2/2003.
No, you did not give the date of upgradation in the scale of 4,500 to 7,000 for.
Yes, my lord, that date is, my lord, by the single order. By the single order, that will appear from page 69, 70, my lord, with effect from notionally with effect from 1/1/96 and with actual benefit from 19/2/2003. 19/2/2003.
And notional?
Notional with effect from 1/1/96. Now,
that is the notional effect of the CPC for all purposes.
Yes, yes. The notional means, it is given notionally. Actually,
yes.
No actual benefit is there.
Correct.
I didn't receive anything at my hand.
Correct. We understand what notional means.
I know my lord knows it because my lord has experience
Please,
in other capacity.
You may proceed. Yes.
Now, my lord, in view of such upgradation, my lord, the department cancel the first ACP to the given to the petitioner with effect from 9/8/99, right? Memo dated, my lord, 27/7/2004.
So this is what you are aggrieved by.
I am aggrieved by that, and my lord, it is there. By being aggrieved by this, the petition was moved at the first occasion before the Learned Central Administrative Tribunal, when the Learned Tribunal was pleased to direct to make composite representation before the authority.
That was OA number?
But I am submitting. I am giving my lord that way now. That OA number, my lord, is OA 312 of 2008.
Yes. So they're directed for making a representation.
Representation which was directed to be considered.
Yes.
Representation was made. That was, my lord, rejected.
Yes.
Challenging that, my lord, the another way was filed before the learned tribunal.
And this arises out of that.
This arises out of that.
Now that rejection order is dated.
Rejection order is dated, my lord, dated 22/12/2008. OA number 461 of 2009. I'm sorry, my lord. There is something, but date is, I'm giving, my lord. I'm sorry. Typographical mistake is there.
Second December 2000.
Yes. 2008, my lord. OA number 461 of 2009. And it was, my lord, order was passed on 13/4/2012. 13/4/2012.
For filing representation.
No. Second way.
No, the first directed for filing representation.
Representation.
Then you said representation was filed.
Yes.
It was rejected.
It was
We asked you the date. You said 22/12/2008.
Yes, the PT.
Then you started telling us about some OA.
Yes, my lord. That it means, my lord, 22/12/2008.
Rejection order was again challenged.
OA number 461 of 2009 was filed, assailing, my lord, the order of rejection.
What is the date of the rejection?
Yes. I'm coming, my lord.
No, 22nd December 2008. Page 49 that one.
My lord will kindly come to page 49. 49 is 22/12/2008. That was the date of rejection.
So that you challenged
That I have challenged, my lord, in next way.
in OA number.
OA number 461 of 2009.
Yes. That was a,
That has been rejected, my lord, in 13/4/2012. Hence, that one, the instant writ petition is filed. Now, my lord, as on the day of, my lord, dismissal of OA, unfortunately, neither of the side was present. The learned tribunal decided the matter expert.
none was present.
None was present, neither for the applicant nor for the respondents.
Last.
দেখো না দেখো
Yes, it says none.
was present. Unfortunately, Mr. J.M. Dasgupta, the learned counsel who was there on earlier occasion, my lord will find, I can hand over the order sheet, that he appeared. Unfortunately, my lord, because of illness, he could not come. And the applicant had no scope, my lord, to pay for any adjournment or otherwise. This was the position, and under such circumstances, my lord, we had to approach this only. Find from the now, my lord will find from the order under the challenge before my lord that the learned tribunal relied upon a judgment of Bangalore bench of Central Administrative Tribunal and thereby rejected. But in my humble submission, the judgment of the Bangalore bench is factually different and on a different score altogether. On a different score altogether. Whereas, my lord, a similar challenge was thrown before the Chandigarh bench.
Where is the order of 27/7/2004 cancelling the ACP benefit?
Yes, madam, I'm coming. Page 54 of the writ petition, madam.
No, it is not. That is supposed to be 27/7/2004.
18/6/2004. Here, my lord, it has been referred to.
The date is
This is a communication, my lord, from Kolkata office. The fund, main order, my lord, is, my lord,
the date that you gave us of the cancelling order is 27/7/2004.
yes.
Now, how can the covering letter be prior to that letter?
No, no, I'm
18/6/2004. It cannot be.
I will kindly, sorry, my lord, I'm stand corrected. I will kindly come to page 47.
47.
47.
No, that is the rejection of your representation.
No, no, 47, my lord. The office order dated 27/7/2004. The rejection order, my lord, is at page 49.
Yes, yes, we have got it. 27/7. Yes.
Now, my lord, this is the position we have filed, my lord. Now the respondents, my lord, have used their affidavit in opposition before this honorable court. But may I refer, my lord, only one paragraph of their affidavit in opposition. Let me kindly turn to paragraph 4, my lord. Starts from page 3 of their affidavit in opposition. But this has been, here it has been stated how the benefit was given and it was withdrawn.
Page.
Page 3 of the affidavit in opposition, my lord, paragraph 4. Consequent upon change in the pay scale of accounts personnel with effect from 1st January 1996 on notional basis by the Government of India with actual payments being made from 19 February 2003, communicated under such and such. A problem has cropped up in this office regarding those junior accountants who were initially recruited as postal assistant, sorting assistant, TS clerk in various field units of West Bengal Postal Circle and has come to this office under Rule 31 of PNT manual, such and such, either as lower division clerk or as junior accountant, and subsequently earned their first class second financial upgradation under assured career progression scheme as per clarification received from the circle office.
So it is the same as what they have said in the rejection order. There is no difference.
Yes. But it is there, my lord. So admittedly, my lord, it was there. Now your lord will kindly consider the order under challenge.
The rejection order.
No. Order under challenge means, my lord, the tribunal's order, my lord, where the Bangalore bench judgment was relied upon and the
How the rejection order is bad, that you have to show us.
but that rejection order was bad because, my lord, the ACP has been has clarified, my lord, in such a manner. But here, my lord, the modified assure career program, my lord, for the central government employees. But I have given, my lord, in my bunch of judgment, I have annexed, my lord, the SAT.
MSCP.
MS.
Bunch of. You have given us a compilation, a spiral binding compilation.
Yes, ma'am.
In this, where is this MSCP? We don't find any such MSCP. You have given judgments, you have given a
No, it starts from, my lord, page 39 of the compile.
central government civil employees 2009,
Clarified, my lord,
page 39.
it starts from page 39.
Yes.
Now, the clarifications given, your lordship will kindly come to page 47. Yeah, the clarification sought for is in a case where a person is appointed to a post on transfer or absorption basis from another post, whether 12 years and 24 years of service for the purpose of ACPs will count from initial appointment or otherwise. The benefit under the ACPs are limited to higher pay scale, do not confer designation, duties, and responsibilities of higher post. Hence, the basic criteria to allow the higher pay scale under ACP should be whether a person working in the same pay scale for the prescribed period of 12 and 24 years consequently, so long as a person in the same pay scale during the period in question, it is immaterial whether he has been holding different posts in the same pay scale. As such, if a government servant has been appointed to another post in the same pay scale, either as a direct recruit or on absorption basis, on first deputation basis, and later on absorbed, it should not make any difference for the purpose of ACP so long as the same pay scale. He did. Okay.
Poster.
All senses on. দেখবে না দেখবে
দিচ্ছে আমাদের তো কপি নেই।
না কপি সাইটের জাজমেন্ট তখন বলে দিচ্ছিলাম তোমার সুস্মিতা
ওইটা আমাদের
বলে আমার নামটা
জুনিয়র
তো আছে হ্যাঁ আমি তো যেগুলো দেওয়ার কিন্তু জানি It's fine. I'm just doing. এটা তো নয় 39টা নয় ভুলে গেলে চলবে ওখানে কিছু নেই যান 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 কিছু নেই যান if that is so, you will also will appreciate. My lord, a pay scale was given on paper, no actual benefit, nothing of this sort, my lord. By that, my lord, the pay scale was merged, and another scale was there. Accordingly, my lord, the financial benefit was given, which was subsequently withdrawn. But in such view of the matter, my lord, the petitioners, my lord, only claim that the benefit withdrawn should be given, more particularly in view of the fact that, my lord, the particular memo of the postal department by virtue of which, my lord, this benefit was sought to be withdrawn. It has been set aside and quashed by the another bench, which has attained its finality up to Supreme.
Which memo?
Yes, my lord.
Which memo? 27/7/2004.
Yes, my lord. May I place the judgments, my lord? In fact, my lord, it germinated, my lord, from 23. My lord, may I place the judgments?
If 27/7/2004 has been quashed, then what remains?
Well, it is there now. That's what I am submitting. You will also, may I place? May I place those judgments?
No, you said that 27/7/2004 has already been quashed
Yes,
and affirmed up to the apex court. Then what
Yes, my
remains in this?
In a similar case, my lord, the similar steps were taken in respect of all India basis. My lord, in Punjab and Haryana, my lord, in Chandigarh bench of the Central Administrative Tribunal, such a challenge.
So impugned order has not been set aside. You are claiming parity with someone
Yes,
under whom you say they are under similar circumstances.
No, similarly circumstances, my lord, there I am showing, my lord, which memo was set aside.
That there are two different things. One is saying that the impugned order has been quashed by another cat and it has been affirmed up to the apex court. Then you should not be here. You are not required to be here. Other is that you are claiming parity with someone who has taken up an identical issue according to you and it has been allowed. They are two different things. Yes.
My lord, can we fix up the compilation?
There you go. Not a copy of the compilation is to be given to us. It has not been given.
My lord, all the
No, no,
references
my lord,
and
I
numbers
was-
were given
I
long back.
was so long
when-
hearing.
No,
I
no,
was so long hearing him. He is arguing some things which are not part of records of the tribunal earlier. He is trying to improve a new case now here in the writ court.
No, we have already said that we are not going to refer to anything beyond the records. He is confining to the records. But these citations and this judgment, you have
My lord, long ago when my learned friend, learned senior friend was not engaged at all. The learned lady advocate who was appearing in court number 11, it was supplied to her. It was, my lord, the references were given. Everything was given. Now that it is denied, my lord, I can supply. What else I can do? But still, my learned senior friend is learned additional solicitor general. I cannot disobey him. I cannot dispute it.
that is not the point. The point is before taking up so much of time, this should have been done.
My lord, I was under the impression since the references were given to my learned friend who was appearing earlier, it need not be supplied because most of the judgments are, my lord, reported judgment, 7 except, my lord, the Punjab and Haryana, my lord, the Chandigarh.
So you will not rely on Punjab and Haryana.
No, I will be relying upon it. I shall supply, my lord. What else I can do? This is the fundamental because that order of the Chandigarh bench of Punjab and Chandigarh bench cat, my lord, was there. There, my lord, the applicants therein succeeded. It was assailed by Union of India in Punjab and Haryana High Court. There they failed. They are against, my lord, they preferred a special leave petition.
You give him a copy, we will hear him on the next date. You complete whatever you are saying.
Yes,
Yes,
I shall give him a copy.
yes.
Now you will also kindly come to the order. Starts from page 27. Here, my lord, Punjab and Haryana, Chandigarh. এই তো পেজ কপি রয়েছে
তোমরা দাওনি।
So whatever it might be, you are in possession of the order.
You are saying something, show the receipt
No.
that you have supplied the whole complaint.
I have supplied the references.
Yes. What about
Repeatedly, I am
what about the
supplying.
compilation and statements?
Yes. Statements were there. Statements were.
No, this we were, see, we are very clear. This we are not going to consider. We have already told him. Whatever this he has filed, we are not going to consider. Nothing beyond the record, not a sheet of paper
Yes,
beyond
my
the
lord,
record.
there is nothing beyond the record.
We don't know. We are not going to refer to that. We are making it very clear. We have marked the pages that you have referred.
Yes.
The 2 orders we have seen. We have taken note of the dates.
Refer, my lord, the other pages also.
Whatever you want to, but no, nothing beyond the record.
Yes.
Yes.
You can see here the post is of senior superintendent of post officer. Since both the applicants have a common cause of action, leave paid for also same, they are allowed. Application. Applicant number 1 initially joined the post of senior superintendent of post officer Srinagar as post assistant and was promoted as UDC on such and such. Thereafter, he was transferred on his own request to senior accountant under para 38 of the manual. Then again transferred on such and such date to director of accounts Ambala under the aforesaid para 31 as senior accountant. He was promoted as senior accountant in the pay scale of 5,000 to 8,000 with effect from 13/1/12/1998. Similarly, applicant number 2 post such and such and subsequently sought his transfer under para 38 and joined the post of director of accounts in Ambala on such and such date. He was promoted as senior accountant in the pay scale of revised pay scale of 5,000 on 1/7/1991. The next promotion from the cadre of senior accountant was to the post of junior accounts officer in the pay scale of 5,500 to 9,000 for which qualifying departmental examination part A and was prerequisite. It is clear since the applicants could not qualify in the part A and B examination, they were not eligible from senior accounts officer. It is further submitted that the respondent lacks the recruitment rules for post of AO 11/1/2002 for the purpose of grant of financial upgradation which were to be granted in scale of next higher grade after 12 and 24 years of service under the assured career progression scheme, thereby doing away with the recruitment of qualifying part A and B departmental examination. According to the applicant, they were granted benefit of financial upgradation in the scale 5,500 to 9,000 for the post of AO, which was revised 6,500 to 10,500 notionally with effect from 1/1/1996 by order dated such and such 19/2/2003. But actual benefits were to be given, granted to them from the city. The grievance of the applicants is that while order dated 18/6/2004, your lordship can take it. 18/6/2004, respondent number 1 has ordered to ignore service rendered by an applicant in another seniority for the purpose of grant of benefit scheme with the result, the applicants who enter 18 and in the same department have been ordered to be deprived of the right of counting their service for the purpose of grant of SCP scheme. Hence, the applicant have filed the present way seeking the following reliefs. Order dated 18/6/2004 issued by respondent number 1, whereby directives have been given to respondent number 4 to exclude the period of service rendered by the applicants in the general line postal wing before joining the account wing under para 38 of PNT manual such and such for the purpose of grant of scheme as was allowed earlier and has sought to be withdrawn from the same by order dated 18/6/2004 without issuing any notice and affording any opportunity of heard to the applicant. Order dated 7/7/2004 passed by respondent number 4 in pursuance of annexure A1 whereby benefit of earlier service granted to the applicant for the purpose of financial operation of PCP has been ordered to be withdrawn under annexure A2 B quos. Order dated 7/7/2004 passed by respondent number 7 in pursuance of annexure circular whereby benefit of their earlier service granted to applicant number 2 for the purpose of financial upgradation under SCP scheme has been ordered to be withdrawn. These were the players when case came up for hearing the week of 9/7/2004 and each member ordered the absence of document for the month of June 2004 subject to ultimate. The applicant has submitted 6 orders have been passed without issuing any affording any opportunity of being heard to them. Thus, null and void, illegal, arbitrary liability costs. They have challenged the action of on various grounds, including that applicants were granted the benefit of previous service rendered by the under the same department of the department in terms of clarification issued on May 2000 regarding SCP scheme according to them. Since clarifications were applicable to all the departments of central government, orders have been issued the department of applications only whereas the same thus. These are violated of Article 14 and 16 of the law. Next round taken by the that the orders have been passed with retrospective effect, which is not legally permissible under liability. In this case, even if the financial obligation is allowed, but the nature and duty of the responsibilities of the government should be the same as like in situ without changing the nature of responsibilities and have to be treated alike. Therefore, the benefit granted to the applicants for the service, first service matter of grant of a scheme cannot be ordered to be withdrawn. The respondents have filed their written statement as well as additional written reply in the form of reply to the joined by the filed by the applicants. It is submitted that both the applicants were appointed in the such and such manner, factual aspect. Thereafter, they were transferred. They needed the lottery can become keeping 2-3 lines. Under Rule 38 of the Manual, Volume 4, as junior accountant, I was promoted to the scale of senior accountant, scale of such and such, which was subsequently upgraded such and such. According to the respondents, direct recruited junior accountants are entitled to for 2 financial upgradation, that is one after completion of 12 years of service, scale of such and such, the other after 24 years of service in the scale of such and such. In the present case, both the applicants were promoted as senior accountant in scale of such and such with effect from 31/12 and 1/7/1991 respectively, and the second financial scale of such and such was to be given to them after completion of 24 years of service as senior accountant. I was directed to second financial upgrade.
Yes, we have gone through it.
Yes.
Yes, we have. Gone.
Now, my lord. Factual aspect now that my lord. After my lord clarifying my lord in paragraph 9, the learned tribunal my lord decided we do not find any legal justification for services rendered by the applicant.
That's not the issue arising in your case. There's no question of excluding any service.
Let me kindly see. Because here you let me kindly see. Then Well, it was challenged. This order was challenged before the Punjab and Haryana High Court.
This order was never challenged. The order that has been passed in your case, the tribunal said you represent against it. That you have represented.
Yes.
They have passed an order.
Yes.
In that order, there is no issue of ignoring any past service length. There is no issue of length of service.
Now, Your Lordship,
There is no question that you don't possess the qualifying service for grant of first or second ACP. That's not the issue here.
Your Lordship,
The issue here is different. They say under Rule 38 of the manual, since you have got a choice posting here, therefore the effect of that, they have said that the effect is that you will lose. And
no,
since
that is
subsequently
also-
an upgradation has been granted,
my lord, that
that's
also
not the issue.
that also cannot be done. That has
That cannot be done is a separate thing. But when you rely on this judgment is on the issue whether they fulfill the requisite length of service, being 12 years and 24 years for grant of ACP at the two stages. That's not the issue arising in your case. We don't know why you have referred to this judgment.
I have referred to, my lord, because it was challenged. Issue was, my lord, withdrawal. That is
This issue is not there. In your case, there is no such issue.
Your Lordship, now, my lord, from
The issue arises from the order of cancellation and the order rejecting your representation. That is the thing. There are only two issues.
whether that can be taken out or not. Your Lordship, kindly now come to page 84 of my copy. '99, volume 2, page 119.
The provision in the MSCP also that you have placed, it is regarding length of service.
Yes, the length of service is there. They are disregarding. Had it been so, my lord, actually, you Lord, kindly see, when the protection of pay was given, only in respect of, my lord, whom request transferred under Rule 38, they can lose the seniority for the purpose of promotion. Supreme Court has clarified that.
All right.
For the purpose of promotion.
See,
And so
we are asking you, we can just listen to you and leave it to that. But we are asking you for a specific purpose. We don't know how you are relying on this judgment. There's no issue of length of service involved in your case.
Now, your Lordship, kind.
Which one? 84. Again, it is on past service, counting of past service, length of service. These are all on issues which has not been raised to deny you or take away the benefit from you. There are just two grounds for taking away the benefit. Explicit from the order dated 22/12/2008. Now 22/12/2008, you have chosen not to place. That order is the basis of the entire thing. And without placing that, you are taking us to judgments regarding length of service. 22/12/2008 is the order rejecting your representation. You have not placed that. You have chosen not to place it, but we have gone through it. Now, there is no issue of length of service in that rejection.
No, my lord, the reason is that under Rule 38, when was one.
Now, that is the issue. Come to that issue. Let us see where is Rule 38. Show us.
Compilation, my lord.
Yes, it is there, sir. Yes, at 96. Transfer at one's own request.
Yes. Transfer of officials with that for their qualifications.
We'll read, just you read, we'll read. Yes.
But the essence of the transfer grace, my lord, person concerned got transferred under 38 will rank junior there. He gets his first service.
He will lose?
He will, it doesn't say that he will lose his first service.
Where is the question? Who is asking you?
Question
Who
because
is asking you to lose the past service?
yes, no,
Who has said that you must lose the past service?
that is not my lord. Then when I did not give any benefit there I didn't get any benefit.
Yes.
Because the scale became my lord identical after revision of scale of pay by virtue of pay they take. Why? How could I be my lord deprived of the benefit of first SCP and second SCP?
All right.
Question of deprivation of first SCP and second SCP, my lord, then my lord, it will be unjust.
All right.
Because your lordship can see they were appointed sometimes 81, 82 or like this. They, my lord, they have not 2 years.
Very
They did not get any promotion. They did not get any promotion. The moment a promotion was extraction, the base scale of that post became identical. Which is the earlier post. If that is so, my lord, then I am entitled to. And that's why, my lord, I am referring.
The clarification dated 18/6/2004 is the clarification dated 18/6/2004 issued by the Personnel Public Grievance and Pension. Is it on record? There is a clarification issued by the Ministry of Personnel Public Grievance on 18/6/2004. Where is that? Is it on record?
That is possibly, my lord, in page 49.
No, it is not in page 14.
Page 49.
No, it is not. 18/6/2004. Yes. It is a clarification.
Act, my lord. Page 57.
'57 is the reply, sir. What are you?
At page 57, my lord, of my
Page 57 of your application. Which application?
application which my lord read.
Page 57 is the reply filed by them, by you or by them. It is not the clarification. 18/6/2004.
2004, my lord, it was as annexure A3. Page 57.
Come to page 57. See what is at page 57.
Yes, ma'am. May I read? Ministry of Communications and Information Technology Department of Post Postal Account.
You are reading from the writ petition.
Yes.
All reply.
Ma'am.
Reply on behalf of the
अरे waiting for
57 তুমি বলছো 57 of your writ petition.
Oh, it's a 57, no, 54. I'm sorry, man. Page 54. Page 54.
All right. They are giving effect to this clarification. Their case is that they are giving effect to this clarification.
Subsequently, clarification, madam, they gave the clarification, madam, in 2001, by virtue of which I have got. Now, madam, what is the reason behind this? And the same clarification, why I was submitting the same clarification was here, my lord, in respect of, my lord, of employees in Punjab and Haryana. 20. Same clarification was there, which has been set up. Cannot produce the original copy, my lord, but the essence of the order shows that such was the clarification. In respect of Kolkata, that was in respect of Punjab and Haryana.
Yes, we have seen.
Then one more thing I was trying to compute. Calcutta, CP of 2009 also have 2009 has clarified in a situation even in respect of an employee, but at page 60 of the compilation.
That is the MACP scheme.
Yes, yes.
'39.
39. But it's a case worse than my clients. An employee is appointed to a lower grade as a result of
It's not a case of persons worse than it is a case of persons who are distinguishable from your client. This will not apply to you. It is nobody's case that as a result of this unilateral transfer, it was on a lower grade. That's not your case. Whereas in your case, the transfer, the transfer was on a post lying between LDC and the junior accountant, somewhere in between.
I am neither saying that.
Then-
What I am saying
Yes,
that even if that in that case also,
that is not the case. That is not the case. That is not the case. That is so. That is not the case. That is a totally different circumstance altogether. That does not apply to your case.
and the very first clarification you will also find at page 46.
Page.
Page 46 of the document. But that is one of the these have resulted in change in the hierarchy. The pre-merge scenario have become one grade. Position will be clarified further by the of the keeping. Now, the clarification scheme are to be allowed in the hierarchy. Under ACP, salary to be higher skill or commander of skill by including the promotion and employee who not moving from lower pay skill, higher pay skill, third of margin of pay skill can be interacting
Ignoring the said promotion.
yes, ignoring the same promotion. Otherwise, you will be placed in a very disadvantageous. Now, my lord, the judges will like going. Your lords will kindly consider this aspect. Here, your lords will also kindly see.
Yes.
The case here, well, I am referring another case. I shall place my those judgments subsequently among one case, though it is in respect of promotion. Well, and we are, my lord, in respect of the, my lord, benefit of ACP. The principle which has been enunciated by the Honorable Supreme Court in, my lord, in the case 1998, volume 5, SCC page 305 at page 74 of my compilation. Scientific advisor to Raksha Mantri and another versus V.M. Joseph.
Reference to
1998, page 305. Like line from the top. Here, the last several lines are even if an employee is transferred at his own pace from one place to another, he paid a charge required by him and the place where he permanent post and acquired power of the standard cannot be excluded from consideration for exact. So he bottom of the seniority is at the transferred place cannot be confused with seniority at the actual.
Which page you are reading?
I'm reading for page 76.
Paragraph?
Paragraph 6, my lord, last 76.
All right. Very good.
My lord has seen my lord the 38 is also.
There are two things. This case that you are relying upon is not governed by Rule 38.
Right. But only
Second thing is, here what it is saying is that the period cannot be excluded.
Yes.
It is not saying that if in between you have got a upgradation, then how it is to be treated for the purposes of grant of.
That's why the clarification I have shown my
So those may be relevant. These judgments, they are on different set of facts. They don't apply to your case. So Rule 38 MACP clarification that will govern the issue. These judgments are on different aspects.
my lord, what I am submitting at the risk of I am submitting, my lord, the judgment of Chandigarh bench my lord, was challenged before the Honorable High Court.
The judgment of,
Chandigarh bench of CAT.
all right, that you have said already. That you have said. As it was challenged, it has attained finality up to the apex court. Yes.
It has been, my lord, I have annexed it and it is at page 25 to 38, my lord, that is order of the High Court. Punjab and Haryana High Court.
That you will have to give to the learned age.
Yes, I said. But he has, by now, he has got it. Now, in any event, one in course of today, I shall supply him.
No, the unreported judgments you will have to give it.
Yes. Even in course of today, that's what I said.
Yes.
One judgment, at least my cat, Chandigarh bench, my landed
Very
trade is
good.
already imposed.
All right. So we will hear you on the next. Take down. Item number 4.
Yes, may I please adopt? As well, as your lordship was pleased to point out to me that in the Railway Board circular dated 2/6/2006, there are two paragraphs. One is regarding merger of assistant loco pilots at the entry grade. That is at page 96. Yes, volume 1. There are two parts of paragraph 2. First, regarding new entrant. Your lordship pointed out to me that there's another paragraph, paragraph 2.
Paragraph 2.
Yes.
Subpara 2.
Subparagraph. Now, here they have referred to another ministry's letter dated 22/9/2004, which your lordship was considered yesterday.
We have got it.
I have got it. My learned friend handed over yesterday. Technical control of loco branches. This is regarding unification of administrative control. We are concerned about my divisional level. 1. Seniority level eligible.
No, there is two things. One, it is talking about control, who is to exercise control. And the other is that depending upon the strength of the diesel and electro running staff, the unification or administrative control may be considered.
Unification of administrative control.
Unification of administrative control may be considered, and proportion at which the switchover shall be made will be decided by the general managers. So in effect, it is saying unification will be decided by general manager.
Now this is 2004, the page 96 of 2006.
Yes.
Now, in their reply, yesterday I placed, my lord, that is at page 179 of the volume 2. At internal page 5, running page 183, they have also stated that only there is a merger of seniority from ALP to senior. Seniority or onwards, there is no merger of seniority, as there was no guideline regarding that.
This is RBE 69.
Yes.
No, this 22/9/2004 is RBE 69. No, it is
69 is, I think, my lord,
2006 one. You are referring to para 5 of this reply,
Yes, just a minute, my lord. Page
page 5.
5. Para
Second one, second one, second one, which is really good.
para 9.
Yes.
Oh. So, my lord, after 2006 up to August 2022, they were separate cadres. Promotions were made separately in 2 wings. For last 16 years after the 2006 circular. And paragraph 10, they also say that they are separate cadres.
So the merger and gradation list are both at composite, or merger precedes the preparation of this gradation list?
Composite. They did not pass any order of merger. They said prepared seniority list, combined seniority list. They have prepared the combined seniority.
Prior to that, there was no
No.
merger.
For the first time on 12th August 22, they combined seniority directly prepared.
And prior to that, till that day, you were senior LP.
No, loco pilot goods, they are also loco pilot goods in their own wing.
So therefore, before that, you had already become a loco pilot.
All are loco pilots, my lord. Starting with assistant loco pilot, senior assistant loco pilot, then loco pilot goods, then loco pilot passenger.
So when did you become loco pilot?
Loco pilot in 2000, I have given the chart, my lord. If your lordship kindly comes to first volume, first annexure, I have given the chart. Your lordship comes to page 92.
For 92 years, you have shown that.
Yes. Loco pilot, first applicant before London Terminal, 10/1/2013. And petitioner number 1 before your lordship here now. he became Raju Kumar Singh. He became, my lord, page 94, serial number 60. He became 15/12/2012.
Yes.
Now, after 16 years, already all promotions have been made.
So 15/12/2012.
Yes.
He became a loco pilot.
Loco pilot. It is goods, actually. Now, after 16 years, the General Railway decided that due to further replacement of diesel, they would merge.
Due to?
Further replacement of diesel loco, they would merge after 16 years. By the time separately promotions were given in 2 wings,
No, but when did the individuals, whatever date they have come into the grade of loco pilot, according to you, that is being now ignored?
that is also being ignored. I'm coming.
From
Now-
where can you show this?
I'll show my lord. Before that, my lord, one thing.
Yes.
Now, how seniority would be fixed? Because due to this replacement,
This gradation list is of loco pilots.
so pilot could.
So what is the date on which one has become loco pilot? If that is not being ignored for the purpose of determining interstate seniority, then what is the
No, first of all, BK Dubey said no.
huh?
BK Dubey's case. I placed your lordship yesterday.
Yes.
They said no. Since they are being merged due to gradual replacement of diesel loco,
Yes.
this would get seniority below the regular electrical
No. We are not on that. We are asking you your fixation of or your placement in the seniority list. How do you say it is to your disadvantage?
Well, firstly, my lord, BK Dubey said it, they will be below us.
Who will be below you?
The diesel side loco pilot. BK Dubey said no, as if they are coming for the first time to the electrical side.
Yes.
BK Dubey, I placed my lord yesterday. Because
That is correct. But then what?
not from on the basis of promotion, date of promotion. They said all will be below the regular local pilot in the electrical side. That was the decision. Let
Yes.
me consider. BK Dubey's judgment, my lord, placed yesterday. Page 103, my lord, of the first volume. Hundred four is a relevant page, last paragraph. It was on a similar question. When diesels are coming due to the replacement, getting merged, what will be this? How the seniority will be recorded?
Yes.
Now, my lord, as it came from your lordship, whether you were even otherwise, my lord. Your lordship asked me whether you were getting the assignment of seniority on the date, on the basis of regular promotion as Loco. Now, lordship kindly come to page 109. This is provisional combined seniority list of Loco pilot schools.
109.
109. Loco pilot goods E plus D, electric plus diesel, in level 6 as on 12/8/2020. Now, lordship kindly see the date of appointment. There's a color.
Yes.
Then date of officiation.
Yes.
The higher grade. Now, if your lordship kindly comes to no, what is not again. Lordship kindly comes to comes to page 111. Ramputa Bhai was the first applicant before the learned tribunal.
Who?
Ramputa Bhai. Serial number 211.
Yes.
His seniority position is 211.
Yes.
Lordship, date of appointment, Lordship will find 111 6/2/2006.
Yes.
Date of promotion officially was 10/1/2013.
Date of officiation.
In the higher grade.
Yes, not promotion. That is officiation.
Promotion ballot. Officiating promotion is given. Everybody is given officiating.
Yes.
Now, Lordship, kindly see first respondent, private respondent. Serial number 177. Lordship, all of theory. Lordship got it. His serial number is 177. He is above me. Now, his date of appointment, Lordship, kindly see 5/9/2006. And officiation 1/9/2014. Similarly, 179. Lordship knows that after K. Meghalachandra Singh, the date of actual officiation will be the date. After me, then my lord. What for? Even so far with this one. 170. No. 182. 180. 179 also, Lordship, kindly see.
Yes.
Now, Kumar Singh Chakravarti.
Ram Pratap Roy is the petition number 1.
Applicant number 1 before the direct tribunal.
And who is
Petitioner
this?
number Rajikumar Singh. Yes, my lord.
And who is Mr. Tiwari is respondent?
Yes, one. Private respondent. Diesel side. He belongs to diesel side. Now, Lordship, kindly see petitioner number 1. Raju Kumar Singh. His seniority is 204. Raju Kumar Singh, you got it?
He is petition number 1.
Yes. Now, Raju Kumar Singh.
Yes.
204. 204. His date of appointment, Lordship. First
31/1/2004.
Officiation 15/12/2012.
Yes.
He is below them.
He is below?
Below 5 respondents.
Yes.
According to K. Meghalachandra Singh, my lord, date of actual. Panel approval.
But he is in one of them is in Asansol, the other one is.
No. All are Asansol. All are Asansol divisions.
No, what is UDL?
Ondal is a station under. Ondal is a station under Asansol division.
Yes. So we'll see what they have to say. Yes. Yes.
My last comment is they should not have ignored the decision of BK Dubey.
That is your first submission.
Even if the Nazar is upheld. And secondly, my lord, K. Meghalachandra Singh is holding the field now that from the date of appointment they will
What is holding the field?
make K Megachandra Singh, my lord, Supreme Court decision, my lord, that not from the date of select list or vacancy.
or panel.
That decision, I have brought it.
Oh. Yes.
When they are not born in the cadre,
This is settled from direct recruit engineers
yes,
of the 70s judgment.
settled by inner parma, then again.
This is settled since then. One cannot claim seniority from a time one was not born in the category.
That is my second.
Study. We have shown the 22/9/2004 that important.
What have you shown?
Is a that now they are showing 22/9/2004 is a
Yes.
month in governmental railway. Well,
22/9/2004. Yes.
It's a relevant circular.
I have just handed over my
Single.
just handed.
Yes, yes. We have got it.
a lot. I'm giving the regulation, some regulation there is there. I'm relying on this document.
May I get a copy?
Yeah, and definitely. And I'm not type charge fully bullshit. Not in the 2004, not you kindly see that. No specific guidelines with regard to when it will be done.
Hmm?
When it will be done. From time to time, that combined seniority list, application, in a separate letter, separate document, separate RB is there. We have annexed in the documents before the Central Administrative Tribunal also. We have opposition and some answer there. This is the first document. Second document was 69/2006. 69/2006. This is the circular of 26/2006. 2066. Then the common seniority in the first paragraph is stated that.
What?
That it is the assistant loco pilot diesel, assistant loco pilot electric.
Can you please use the mic?
This page 197. Page 197, annexure 7 of the
Yes.
volume 2.
Yes.
No, volume 2. Assistant loco pilot and diesel assistant loco pilot electrical.
Yes.
The Roman 2.
This is
Wherever separate cadres exist, their merger will be considered applied analogy.
this is the same as page. This is the same as page 96.
That is their document also. That
Page 96. Both are same.
both are same.
Yes.
Now, Lordship, kindly, I'm showing another letter. 15/1/2016.
16/1.
15/1/2016, page 191 of volume 2. Is annexed to it our reply before this cat. Page 191. I'll see that with the increased electrification of various sections in the railway carrier proposal, diesel LPS, and that of electrical LPS have progressed systematically. As electrification has progressed, requirement of diesel drivers has come down and electric drivers has gone up. Consequently, promotional prospects of diesel drivers has shrunk, whereas the prospects of electric drivers have expanded. In the existing policy, maintain the railways to train new assistant loco pilots in single sex traction training, either diesel or electrical section, and different seniority list is maintained by the division. With a view to finding solution to the problem mentioned above, it has been decided to give dual traction training to new LPS, and common seniority may be assigned henceforth by the division after posting of new LPS, assistant loco pilot. On introduction of the common seniority, LPS allotted to diesel wing and electrical wing, having dual training will report a divisional, and division may prepare seniority list based on the marks obtained by candidate as per guideline lead time 303A of IRAM volume 1.
That 303 you have just given us.
In the order sheet, it was mentioned by the tribunal. Yes. I'm coming to that question. Further, if a batch of LPS electrical and diesel batch, electrical and batch of diesel electrical reports on the same day, the seniority may be determined based on inter-seniority following the guideline 303 and 304 of IRM volume 1. I am just now giving to IRM 303, 304. I rely on that. The issue of dual training and common seniority of existing diesel and electrical drivers may be addressed by the division as the seniority of drivers is maintained division-wise, and also because situation to reach the division in terms of number of drivers, the two categories progress of electrification, etc., is different from other division. Division may finalize the issue in consultation with the local recognized union, and this issue with the approval of the general manager. Now, Lordship, come to letter dated 12/12/19. 12/12/19, Annexure 2, page 192, volume 2. A reference has been received from Howrah Division, section certain clarification of the section procedure by method of assessment of vacancies, maintenance of roster committee, promotion, and mentions assessment of suitability for promotion, the post of senior LP diesel electrical in level 4 from the merged grades of LP diesel electrical level, etc. The matter has been considered and para-wise clarification. Assessment of the vacancy of senior LP diesel and senior LP electrical is to be made separately following existing procedure, and addition to be made thereafter. Suitability test is to be conducted by the basis of the APAS SR as applicable to non-selection process. Suitability test to be done as a committee due constituted in terms of the officer later E so and so 2018 and dated 9/11/18 as per existing guidelines applicable to non-selection process. As the stipulation of para 4 of the minutes circulated by later under reference to single roster is to be maintained after promotion and from LP diesel and LP electrical for the hire of senior LP diesel and electrical. Apart from that, the above of the seniority of direct recruits, LPS will be assigned as per provision of para 303 and 304 of IRM volume 1 revised edition, as the case may be, irrespective of the fact whether they are trained in traction and dual. Further, when a candidate is posted after single training to traction, the marks obtained in that training in describing order of the descending order of the guideline circulation of assigning seniority. In case of dual training, seniority will be assigned on the basis of average marks obtained in both the training in descending order. Other condition as seniority as per this para 303 of ION volume 4 IVD may be to be taken into account. Issue will be approved to the competent authorities. Now come to RB circular 29/22. This is the letter. Annexure 9, Annexure 4, 5, 6, 7, 8, 9. Lord, kindly come to page 203 of volume 2. The Annexure 9. Now, if you kindly see the right hand side, it stated RB number 29/22. RBE number 22.
Yes, 29.
29/22. Then you will date 14/3/22. Filling up promotional vacancies of loco running cadre and merger of cadres into loco pilots, electrical and mechanical. Railway Board letter dated 6/26/2006. Kindly earmark 2/6/2006. Railway Board letter of event number dated 7/2/22. As per data furnished with zonal railways left enclosed, it is noticed that there are a large number of promotional vacancies in the cadre of loco running staff, particularly the higher grades of male express passenger driver loco running staff, being critical safety categories. Posts are required to be filled up on an urgent basis, as vacancies in the cadre have an adverse impact on train operation. Zonal railways may therefore take urgent necessary action to fill up the promotional vacancies in the cadre. Further, as per instructions contained in Board and so, dated 2/6/2006, the cadre seniority of loco pilots, electrical and mechanical were required to be merged. However, from the position advised of zonal railways, it is seen that these instructions have not been complied on some zonal railways. It is requested that this instruction may be finally implemented across all divisions. New railways under advised board. Action taken in the matter should be informed, not later than 3/2. Then again come to 5/8/22 later. Yes. Tashif, kindly look page 193 of volume 2. Subject.
Yes.
Merger of cadre seniority of loco pilots, electrical and mechanical. The view to implement the instruction railway board for merging of the cadre seniority of loco pilots, electrical and mechanical. The following steps should be taken by the division. The cadre seniority of loco pilots, electrical, mechanical at all levels. They have stated paragraph JK, 4JK, 4K. That specifically stated there are no higher levels mentioned in all levels. In their volume 1, their OA application, they have stated before the CAT. Absolutely wrong contention taken by the learned friend in this manner. All levels should be merged with the immediate effect, and the combined seniority list of loco pilots, electrical and mechanical should be drawn, taken into account their date of entry in the existing grade. That is the main thing. Seniority should be possible movement may not. The seniority of the cadets for the date of the entry to the grade, seniority cannot be lost. In the case of Millard, when the promotional panel list when published, 100, 200, taken only 50%, 50% not taken it. At a stage, my lord. Obviously, that taken later on. What only seniority lost? That juniors with the promotion, get it? They have now the allegation stated that. It is a combined seniority list. It is a policy decision. The administrative decision. How can it be challenged before the court of law? The cadre seniority of local pilots, electrical, mechanical, all levels should be merged with immediate effect. And combined seniority list, local pilots, electrical, mechanical should be drawn, taken into account the date of entry to existing rate. Combined seniority list should be prepared after thorough checking and published by 2012-8-22, and a copy of the same should be provided to both the recognized unions and local pilots of suggestions, if any, within a period of 7 days. No comment about that. No letter issued. Any allegation regarding this issue. Keeping suggestions in mind, division should publish combined seniority list as per extant rules, and representations from the state seniority list would be invited for the next 15 days. Further, within 7 days, combined seniority list shall be published after disposal of the representations, if any. Selection suitability test for which notification has already been issued should be completed as per criteria mentioned in that particular petition. Division requested to communicate the developments on the above issues at regular intervals to this office before initiating promotion in the grade from the marked seniority list. The issue with the approval of competent authority. That is, RBA 2922, just later 5822, stated issues to the approved of the competent authority. Next letter, my lord, 29/9/22. Yes. Page 196 of the volume 2. Merger of cadre, seniority of local pilots, electrical and mechanical. This office earlier letter event number 5822. A joint meeting with both the recognized unions of the railway was held 21/9/22, wherein the subject issue was thoroughly discussed. In this regard, it is requested to please furnish the latest vacancy position in loco pilot cadets in each category separately for electrical and mechanical, where merger of cadre of loco pilot has not been finalized for better appreciation of the position. The position should be submitted by October 10, 22. It may be indicated here that during the joint meeting with the recognized union, it was decided that method of drawing combined seniority list of local pilots, electrical, mechanical, shall be taken into account in date of entry in the existing cadre. In this collection, it is stated that while drawing the combined seniority of each category of local pilot, the provision contained in serial number 5, number 320 of chapter 3 of IRM volume 2 may be followed. This is for information necessary. Action, please. Now, Lordship, I am giving you the regulation.
Yes.
Regulation. I'm just giving the time. Rules, regulation, seniority of railway service.
The compilation that you have just given.
Yes, yes.
Yes. You are referring to 320.
30, 305 and 304. Next page.
Why you mark the? Why you mark?
My officer concerned that too, and I'm sorry.
You don't tell them that how
Absolutely,
this is
absolutely
not the way to hand over
Only-
documents to a court.
That's right.
He is new in the department. He doesn't know.
I'm apologizing for your lordships. Don't take it.
Yes.
305. When, however, a candidate with seniority under paragraph 303 and 304 above cannot join duty within responsible time after receipt of the orders of government. Just I have submitted before your lordship the same thing in the circular. The appointing authority may determine his seniority by placing him below all the candidates selected at the same examination. Selections were joined within a period allowed for reporting to duty, or even below candidates selected at subsequent examination. Selections were joined before him. Now 306. Candidates selected for appointment at an earlier selection shall be senior to those selected latter, irrespective of the dates of posting, except in the case of paragraph 305 above. And now 309, seniority of promotion. Paragraph 306 above applies equally. Seniority in promotion vacancies in one and the same category due allowance have been made for delay if any in joining the new post in the exigencies of service. In the exigencies of service. Now we have come to 319. Seniority on promotion to no selection post.
Yes.
I'm only highlighting the portion. Railway servant once promoted in his turn after being found suitable against a vacancy, which is known for issuers, should be considered as senior in that grade to all others who are subsequently promoted after being found suitable. This is the guidelines issued by the railway.
Yes.
Now, Lordship, question of relying on a judgment VK Dubey case, my lord.
VK Dubey's case. Yes.
VK Dubey case, in this case, not applicable at all. Because, my lord, diesel side should separate stop. Diesel side
Diesel side.
is a separate stop of steam side was declared surplus. Apex Code order of steam side employees will be placed in the seniority below the staff diesel side. But the instant case, diesel staff has not been declared surplus because the electrical and diesel department exists a separate combined structure on the date of merger. This judgment cannot be applicable in this particular case. Another thing, kindly lordship, keep in mind three contention on behalf of respondent. Three contention of that. Irrespective of date of posting in the grade Loco pilot goods, the first contention. Second, exigencies of work. Exigencies of work. Third, has been taken into consideration for assignment of seniority. Panel seniority not broken. Panel seniority is same thing. Cannot be broken. And 320 RM, my lord. 320 RM.
Length of continuous service on equivalent grade. 320 is
Yes,
saying that.
it's mentioned in the judgment.
Yes.
320. Yes, 5 and 5.4, we have also relied on 320 there. And admin also. 320 is also in this circular also. 320.
Yes.
That the relative seniority of employees intermediate grade belong to different seniority. It means appearing for selection, non-selection, post in hierarchy. That is posted. In 2004, I'm also relied on actually. 2004, that's circular law. Zonal authority of DM has been authorized in 2004, just I'm giving 2004 circular.
22/9/2004.
Yes. The zonal authority of DM has been authorized to decide the merger of two cadres, 60% of electrical, no separate department, common department, under the administrative of the staff 60%. 60%.
22/9/2004 talks of 60%.
It's, yes, 60%. The two cadres 60%. It's not to 2004. It's a regulations that is 26/2006 million. 26/2006.
26/2006.
RBI circular 69 of 2006.
Yes.
That provisional levels. Number 3, Roman 3.
Yes.
For day-to-day working electric and diesel crew report separately to officers of the two departments. The day-to-day technical control working includes assigning of duty, performance, monitoring control of leave, annual confidential report, etc. Administrative control of the cadre of division to be given to the department which has more than 60% on roll staff.
How does that affect the determination of inter-se seniority? That doesn't have any. This has nothing to do with determination of inter-se seniority. Perhaps 320 is the one that you are relying upon. IREM 320.
320. The gist of the 320 million, my submission according to my instruction million, the placing of staff combined seniority, combined relative seniority in terms of date of publication of panel.
In terms of?
Terms of date of publication of panel.
320. See what 320 says?
No, 320 contention, my instruction that is in 320, that the placing of staff considered relative seniority in terms of date of publication of panel. Here, my lord, the post of selection as well as non-selection is filled by considering staff of different seniority units. The total length of continuous service in the same or equivalent grade held by the employee shall be determined factor assigning internal seniority, irrespective of date of confirmation of the employee with lesser length of continuous service compared to another unconfirmed employee, the longer length of continuous service. This is subject to the proviso that only non-40 year service should be taken into account for this purpose. That of earlier I have decided, I've raised this point. Non-40 years score.
About the examples that he has shown us.
Which was Melo?
You have nothing to say about the examples that he has shown us.
Example of?
He was showing from the gradation list.
Yes, some coming Melo.
Yes.
And coming to judgment also, passed by the trial.
What is this second? Submission, you will take instruction. For every submission, you will take instruction in the courtroom. Very unique way of addressing the court.
Can I allow to submit my officer concern in the
Huh?
officer concern Asansol division, my lord?
Yes.
Can it be submission regarding this particular issue?
No,
Just explain
sir.
that.
No, sir. This is the way a court proceeding is conducted.
That is why I want to take advice, your lordship. I am not.
Why should you ask such a question? He has got you here, he has got two lawyers here, still he will speak.
Absolutely, absolutely.
And for every submission, you are taking instruction from him. It's a
Yes.
very unique way of making submission in a court. As if this is your consultation chamber.
On page 39, the way application filed by the petition.
Yes. Yes, sir. 85.
85. 4G. I've also just now I have page 84, volume 1.
Just now you said 39. Page 84.
Para 4.
What you are submitting, from where you are reading, we are totally clueless.
The para 4 of the same way.
Which page, sir? You said 84. 84, there is no para 4.
84 is a volume 1. Volume 1 para.
Obviously, 84 has to be in volume 1.
46 will.
Para 4.
4 internal 4J surplus J.
Say J, you are saying para 4.
Para 4J.
Yes.
Here, Lordship, can you see the applicant state the Railway Board's letter dated 2/6/2006 clearly stipulated and are instructed to mass the cadres and level assistant loco pilot who wins diesel and electric and not at a higher level at all as stipulated in the headquarters Eastern Railway letter dated 5/8/2022. My Lord, in the same letter also was relied on. That is not the
They have assailed,
all level.
they have assailed 2/6/2006.
Yes,
2/6/2006 is under challenge.
yes.
And you are reading provisions of 2006.
2006 also, this is the provision merger is already given in the.
According to them, this is not, according to them, this is contrary to the decision of the Supreme Court.
Supreme Court for weekend-to-based case.
Yes.
Absolutely wrong, because it's not applicable in our case.
All
I've
right.
already stated that.
All right.
Absolutely wrong case.
Very well.
I've stated that in just now I stated that weekend-to-based case is not applicable in this particular case below, our case. Weekend-to-based case, I have given you that the instant case, diesel staff has not been declared surplus because the electric and diesel department existed separate combined structure on the date of merger. How the weekend-to-based case is applicable in this case? Absolutely nothing case of this year.
All right.
I'm also realized some Supreme Court judgment regarding retirement.
To us, give us the judgments.
But you copy they get to arrangement. It isn't there. Yes, it isn't there. In 2002-10 Supreme Court cases, page 90-96.
Page?
Page হচ্ছে এটা ছিল, এটাতে আছে আমাদের ইয়েতে।
Page কত?
পেজ হচ্ছে ওই এস মুরগান আনাদার্স, এটা তো দেখেছি দেখানো। Service law cadre, merger of two cadres, challenged to on the ground of its effect of the seniority, combined seniority list prepared by merging together the mechanics cadre and engineering cadres as per the decision of tribunal in this regard. Appellants mechanics assigned the merger of said post on the ground that they were not bound by the tribunal decision as were not parties to the same. Held constitutions and formation of cadre in this prerogative.
You are placing the head note.
Yes. Now, in the I'm relying on. The appellants belonging to group mechanics working in the heavy vehicles factory in Avadi, Madras. The sole grievance of the appellants in the mechanics form cadre by themselves, whereas those belonging to the engineering group belonging to another cadre and they could not have been merged together, and combined seniority list could not have been drawn by such combined list, affects their future chances of promotion of the applicant belonging to the mechanist cadre. It appears that there was some disparity of pay between the employees and mechanists and cadre and corresponding employees in the engineering cadre who belong to the different discipline of welders, blacksmiths, filters, etc. The government, by decision dated 1/12/94, removed the disparity and made one scale to pay, meant for all these people. It is only thereafter, when in 1992, two separate seniority lists were drawn, one the mechanics and other for engineering group. The decision was assigned by filing a writ petition by persons belonging to the engineering group, while the matter was pending before the High Court on the Administrative Tribunals Act, having come into force. The matters was transferred to the tribunal, and tribunal ultimately allowed the same, which attained finality, not being assigned any further. Necessary effect of the aforesaid decision of the tribunal is that both these groups of employees, namely persons belonging to the mechanics groups and the persons belonging to the engineering groups, from a combined cadre, and therefore the combined seniority list was required to be drawn up. In fact, all the ordnance factories, except the factory Abadi, the employees belonging to this fact group.
Here, there is no claim of any disparity in the seniority. Here, there is a claim regarding some salary element which has been resolved. That is not the issue here.
Why you are relying upon this?
I am showing another judgment. 2015, 9 Supreme Court cases, page 2657. Yes, ma'am.
657. 2015.
2015 SCC কত পেজটা
657.
Paragraph 14 and 23, madam. Yes. I'm placing that the judgments. I'm placing.
You are not trying to justify the policy. You say it is not open to judicial review. That is your stand.
Right.
Yes.
Paragraph
So whatever policy you frame cannot be looked into by the court.
policy decision may not be the administrative order, different type of the order, one order is passed, my lord. Time to time, I have shown, my lord, that different time they extended the policy decision, but the date of promotion.
Very well. Any other judgment?
conclude today anyway.
7/4 Supreme Court cases 737.
4.
2007, 4 Supreme Court cases
737.
737.
Your Lordship, I think original said matter will take some time hard. My matter is long below 121. I leave the court my personal difficulty. If reaches, then it may pass over for today.
Ask someone to make a mention when it is called.
If you oblige, then
Yes, call the list.
Application adjourned serial number 1 is essentially
I'm hearing a lot for the appellant.
petitioner of the respondents.
It has been assigned. We have
Yes,
put it
It's been
on board
assigned.
to fix a date. When do you want?
very well. No difficulty. Malad, the entry mod we have. Malad, the entry mod has been subsisting. Malad, from Malad, it was granted on 8th April 2024. It's been Malad subsisting. It subsists Malad till April 2025. So Malad, any day Malad convenient.
Till April 25.
Yes, Malad, it's still April 2020. 30th April. Malad, we were the writ petitioners.
Give us a date of convenience.
Malad, any every day Malad takes. Malad, then Malad, if it's possible, Malad, then after the 21st, Malad, subject to Malad's convenience, Malad, 24th to
21st
Malad, 22nd, Malad, if it's possible.
April.
Yes, Malad. Or Malad, before that, I don't mind, Malad.
From 21st to 2nd May, we are in some difficulty.
Then, Malad, the 10th
10th
April or 11th April, Malad, if it's 10th April is Thursday, or 11th April, Malad, whatever.
Yes, sir.
On Thursday.
So we said, give us a date of convenience. That is why we said 10th is convenient.
Yes, Malad.
All
10th, list on 10th. We'll keep it at 2 p.m.
Yes, Malad.
original set matters taken up.
Yes, at 2 p.m. Malad.
Ah,
Will it kindly come to the first volume of the compilation? page 181. And it is the first permission granted by Reserve Bank of India. In November 1993, Lordships would find permission granted to Ruby General Hospital. Kindly come to paragraph 2. We advise that we are agreeable in principle to your issuing equity shares and such cumulative preference shares amounting to such and such. We advise that we are agreeable.
Yes,
No direction.
it was a permission. This you submitted. Yes.
Now kindly come to the next document, my lord. Next came, my lord, kindly come to page 206. Kindly see Reserve Bank of India issuing, my lord, in March 1997. Approval under section 19(1)(d) of the FERAD. Then the second paragraph. We hereby grant you approval under section 19(1)(d). My lord, this, my lord, because by 1997, my lord, disputes broke out between the brothers. So, my lord, complaints were lodged by the company. Kindly come to page 212. Yes. Letter from Ruby General, the company, to Reserve Bank. We are in receipt of a photocopy of your letter dated such and such, letter number such and such, dated illegible, addressed to us from one Arun Saini, a Delhi-based chartered accountant. Then kindly come to the last paragraph. We are enclosing certified copies of letters sent to you to your head office in Bombay for your ready reference and kind perusal. You may please note that the board of directors of the company decided not to send any application to Exchange Control Department, Reserve Bank of India. And then the last paragraph. Please do note that Dr. Kamal Kumar Dotto, NRI, has vacated office as chairman and director of the company on 24th February 1997, and necessary documents have been filed with the Registrar of Companies. Now, all these, my lord, decisions were set aside by the Supreme Court. My lord, I have placed the order of Supreme Court, 2006 order. Then, my lord, this letter was followed. Kindly come to the next document at page 214. Yes. The letter was, my lord, if your lordships, my lord, coming back to this letter at page 212, a letter from the company.
Yes.
No individual, my lord, right was espoused. And kindly come to the page 213, the signature signed on behalf of Ruby General by the financial controller and secretary, not by Shoju. Now kindly come to page 214. The second letter from the company. Thank you very much for your courtesies, etc. we are given to understand that Dr. Komul Kumar Dotto, in his alleged capacity as chairman of the company, had submitted a number of documents for seeking the aforesaid approval and ultimately collected your letter addressed to the company in original on 22nd or sometimes in March 1997, representing himself as chairman of the company. The company as of date has not received any official copy of the approval from Reserve Bank. In this connection, please note that Dr. Komul Kumar Dotto had vacated office as director of the company on 24th February 1997 by operation of law as per section 283(1)(g) of the Companies Act. Now, on the basis of these letters, Reserve Bank had initially, my lord, withdrawn the approval. Now, kindly come to page 220. Addressed to the managing director of Ruby General. Then, dear sir, approval for issue of such and such equity shares under section 19(1)(d) of FERA. Please then the letter, body of the letter, please refer to your letter dated such and such. On the caption subject, in this connection, we advise, having noted the contents of the papers documents furnished by you, that our above approval, vide letter number such and such, dated 22nd March 1997, has been obtained in suppression of your company's decision for non-submission of application and issue of shares against import of second-hand machinery, and that Dr. K.K. Dotto NRI, who had applied, personally received the said approval in his capacity, in the capacity of his being a director of the company, was not a director, was no longer a director at the time of applying for issue of shares. In view of the above, we advise you to treat the approval dated 22nd March 1997 as withdrawn. Thereafter, my lord, kindly come to page 224. Further representation steps were taken, and ultimately, my lord, page 224. Reserve Bank's, my lord, this is, my lord, the basis of the writ petition from which the appeal arises. Approval for issuance of such and such equity shares, please refer to the correspondence resting with our letter dated such and such. On reconsideration of the matter, we advise that it has since been decided to reinstate the validity of RBI approval contained in our letter dated 22nd March 1997. Accordingly, we advise you to treat our letter number such and such dated 2nd June 1997 as withdrawn and arrange to issue such and such equity shares, etc. Now, my lord, as I said, my lord, this led to filing of, my lord, the complaint and, my lord, the writ petition. Kindly come to page 254 once, my lord, the second one. The orders impugned, my lord, I had placed these orders. 254 is the first order. In fact, this is really merged. According to me, it has really merged into the second order at page 258. Kindly come to page 258.
258.
258. The background: by an order dated 22nd March 1999, Honorable Justice Ray, Calcutta High Court, in writ petition number such and such, had directed Reserve Bank of India the third respondent in the above writ petition to grant a personal hearing to the writ petitioners, etc. And, my lord, omitting 3 lines, and make and publish a reasoned decision in the matter of grant of approval, both as regard to section 19 and section 29 of the FERA 1973. He had also directed in the said order that particular attention had to be paid as to whether the approval shall at all be granted or not, whether the approval shall be on non-repatriation basis alone, whether there shall be any monetary limit or limits to the number of shares which shall be the subject matter of such approval. Now, after this, well, kindly come to, I am omitting, kindly come to, I had placed this order in extension before. Kindly come to page 272. The second paragraph. I am of the opinion that the Reserve Bank has a rather limited role under the provisions of FERA 1973 in the dispute between the parties, and there are 3 issues to be addressed. I will address them serially as follows. First issue, whether approval shall at all be granted or not. In terms of section 19(1)(d), any person, which includes a company, has to obtain RBI's permission before issuing shares to a person resident outside India. Section 19(1)(d) of FERA 1973 reads as follows, my lord. I shall place the section later on. From the above, it is clear that any person which includes a company can issue shares to NRI only with the prior permission of RBI for issuance of such shares. The issuance of shares can be on repatriation or on non-repatriation basis. RBI permitted issuance of shares on repatriation basis when foreign remittance was received through normal banking channel or when there was capitalization of new equipment supplied by NRI. If the equipment supplied were second-hand, then the capitalization of the same was allowed on non-repatriation basis. Admittedly, in this case, the equipment supplied by Dr. K.K. Datta were second-hand and there is no dispute on this point. SIA approval was obtained on 6 August 1993, in which non-resident equity participation allowed is such and such. SIA later also states that project envisages import of capital goods worth ₹420 lakhs to be financed out of NRI investment. The import of the equipment was governed by then EXIM policy, in terms of which there was no restriction on import of second-hand capital goods. Thereafter, on 4th November 1993, in principle approval was granted by RBI for issuance of shares on repatriation basis during the financial year 1994-95 and 95-96. Dr. K.K. Datta supplied imported second-hand medical equipment and applied for shares against the second-hand equipment. The import of such medical equipment against which shares were to be issued, pending RBI permission for the same, was reflected in the annual report and balance sheet of the company for the year ending 31st March 1995 and 31st March 1996. This fact was also known to Shajul Datta, as he had signed the above balance sheets as director of the company. The above balance sheet also showed income over rupees such and such from out of the operation of the hospital, obviously with the use of equipment supplied by Dr. Datta and commissioned by the hospital. The permission granted by RBI with a letter dated 22nd March 1997 was on the basis of Ruby General's application dated 17th March 1997, signed by Dr. K.K. Datta as the chairman of the company, enclosing thereto all the requisite documents. The same was scrutinized
Marked by us. You had placed this.
Yes.
The entire thing is marked by us.
I will not, my lord, I will not waste your lordship's time.
The sum and substance is that it has held that since the CLB has already held that the earlier decisions were
Kindly come to
ineffective.
page 275.
275, yes. It starts from the bottom of 274.
That's true, my lord.
Incidentally, the CLB from there.
Yes, absolutely.
So
Absolutely.
that is
And
a
275, in view of the above,
Yes,
I am of the opinion that the RBI's permission for issue of shares shall be granted.
unless there is anything else prior to this.
This is.
Yes.
This is. Now, my lord, if your lordships are pleased to come to my lord once, the first volume, page 1.
FEMA.
Yes. My lord, portion of the Foreign Exchange Regulation Act has been, my lord, given. Kindly come to page 2. My lord, we are concerned with this, my lord, section 19, regulation of export and transfer of securities. Then 19.1. Notwithstanding anything contained in section 81 of the Companies Act 1956, no person shall, except with the general or special permission of Reserve Bank, kindly come to D, issue whether in India or elsewhere any security which is registered or to be registered in India to a person resident outside India. It does not, as I have already submitted before your lordships, it does not contain any direction. It's only a permission. Now, it was entirely on the company, my lord, to decide its course of action.
Having obtained this permission from the statutory authority, it was up to the company to take a decision.
And my lord, interestingly, my lord, I would say, my lord, HERA was repealed in 1990. Subject to correction, the next act, my lord, Foreign Exchange Management Act, FEMA, 1999, does not contain, my lord, any such similar, my lord, restriction. These applications were made before this continued. But if these applications were not made, possibly, my lord, all these, my lord, exercises were not required.
So now there is no, the act does not
Subject to
contemplate.
Subject to correction, my lord, and section 49 of FEMA, my lord, I have also annexed. Foreign Exchange Management Act, my lord, kindly come to page 4.
Yes.
Kindly come to page 6.
Yes.
49, my lord, saving, repeal and saving. The Foreign Exchange Regulation Act 1973 is hereby repealed and the appellate board constituted under subsection so-and-so of section 52 of the said act shall stand dissolved. Then kindly, 2 is on the dissolution of the appellate board. Then 3, notwithstanding anything contained in.
So the effect of this repeal or this.
Only is, my lord, kindly come to 5, notwithstanding such repeal, anything done or any action taken or purported to have been taken, including any rule, notification, inspection, order, or notice made or issued at or any point, or any appointment, confirmation, or declaration made, or any license, permission, authorization, or exemption granted, or any document or instrument executed, or any direction given under the Act, hereby repealed, shall, insofar as it is not inconsistent with the provisions of this Act, be deemed to have been done or taken under the corresponding provisions of this Act. This is all. Now, my lord, as I have already submitted before your lordships, my lord, that the
Yes.
writ petition, when it was filed, had 2 petitioners, Ruby and Shojul.
Yes.
Thereafter, my lord, Ruby's name was struck off. So the writ petition continued to be a writ petition by Shojul alone. Now, my lord, I have placed before your lordship the writ petition in extension. So, my lord, it does not show any personal legal right or cause of action of my lord Shojul. The writ petition The cause of action in the writ petition, if at all any, was of Ruby and none else. Now, my lord, in this connection, my lord, on the Locus, my lord, I was addressing your lordships, my lord, on the question of Locus. May I rely on certain judgments? 62. Well, the first one I would like to rely on is reported in AIR 1962 Supreme Court 1044. Kindly come to paragraph 5. Paragraph 5 at page 3. The first question that falls to be considered is whether the appellant has locus standi to file the petition under Article 226 of the Constitution. The argument of learned counsel for the respondents is that the appellant was only managing the industry and it had no proprietary right therein, and therefore it could not maintain the application. Application. Article 226 confers a very wide power on the High Court to issue directions and writs of the nature mentioned therein for the enforcement of any of the rights conferred by Part 3 or for any other purpose. It is therefore clear that persons other than those claiming fundamental rights can also approach the court seeking a relief thereunder. The article in terms does not describe the classes of persons entitled to apply thereunder, but it is implicit in the exercise of the extraordinary jurisdiction that the relief asked for must be one to enforce a legal right. Now, pausing here for a moment, the permission by Reserve Bank, my lord, did not grant any, my lord, or did not affect any legal right or any right at all. The right, if at all, of my lord Schedule which could have been affected was by issuance of the shares, which was challenged by Schedule by filing an application before CLB and which was ultimately dismissed, as I have placed before your lordships. Now, may I continue? In state of Odisha versus such and such, this court has ruled that the existence of the right is the foundation of exercise of jurisdiction of the court under Article 226 of the Constitution. In such and such, it has been held by this court that the legal right that can be enforced under Article 32 must ordinarily be the right of the petitioner himself who complains of infraction of such right and approaches the court for relief. We do not see any reason for why a different principle should apply in the case of a petitioner under Article 226 of the Constitution. The right that can be enforced under Article 226 also shall ordinarily be the personal or individual right of the petitioner himself, though in the case of some of the writ like habeas corpus or quo warranto, this rule may have to be relaxed or modified. The question therefore is whether in the present case the petitioner has a legal right and whether it has been infringed by the contesting respondents. The petitioner entered into an agreement dated 24 July 1948 with respondent number 5 in regard to the management of Oriental Gas Company. Under the agreement, the appellant was appointed as manager and the general management of the affairs of the company was entrusted to it for a period of such and such. The appellant would receive thereunder by way of remuneration for its service, etc., such and such. In its capacity as manager, the appellant company was put in charge of the entire business and its assets in India, and it was given all the incidental powers necessary for this aid management. Under the agreement, therefore, the appellant had the right to manage Oriental Gas for a period of 20 years and to receive the aforesaid amounts. Now, my lord, here again, my lord, Shojol, whatever he did while filing the writ petition was in the capacity of the managing director, without any personal, my lord, right being involved. Now, my lord, the next decision I would like to rely on is reported in 2012. Volume 4 Supreme Court Cases, page 407. Two 2012 4 SCC 407. Kindly come to paragraph 58 once. 58. Lordship's got it. Paragraph 58. Sri Chintaman, ex-president, was the complainant. Thus, at the most, he could lead evidence as a witness. He could not claim the status of an adversarial litigant. The complainant cannot be the party to this list. A legal right is an averment of entitlement arising out of law. In fact, it is a benefit conferred upon a person by the rule of law. Thus, a person who suffers from legal injury can only challenge the act or omission. There may be some harm or loss that may not be wrongful in the eye of law because it may not result in injury to a legal right or legally protected interest of the complainant, but judicially harmed of this description is called damnum sine injuria. The complainant has to establish that he has been deprived of or denied of a legal right and he has sustained injury to any legally protected interest. In case he has no legal peg for a justiciable claim to hang on, he cannot be heard as a party in a lease. A fanciful or sentimental grievance may not be sufficient to confer a locus standi to sue upon the individual. There must be injury or a legal grievance which can be appreciated and not a start process, and that is a claim devoid of reasons. Under the garb of being a necessary party, a person cannot be permitted to make a case as that of general public interest. A person having a remote interest cannot be permitted to become a party in the list, as the person who wants to become a party in a case has to establish that he has a proprietary right which has been or is threatened to be violated for the reason that a legal injury creates a remedial right in the injured person. A person cannot be heard as a party unless he answers the description of aggrieved party. Mallard cases are Mallard referred to then. The High Court failed to appreciate that it was a case of political rivalry. The case of the appellant has not been considered in the correct perspective at all. In such a fact situation, the complaint filed by respondent number 5 could at the most be pressed into service as a material exhibit in order to collect the evidence to find out the truth in the instant case. as all the charges proved against the appellant have been dealt with, etc., etc. Now, my lord, here again, my lord, as I have submitted, my lord, repeatedly, in fact, that my lord, Sojol did not make out any individual case, any case of infringement of any legal right of his in the writ petition. My lord, this is the consistent view, my lord. The next one, my lord, is reported in 2013, volume 4, Supreme Court cases, page 465. Kindly come to paragraph 9. Kindly come to paragraph 9. Nay. It is a settled legal proposition that a stranger cannot be permitted to meddle in any proceeding unless he satisfies the authority code that he falls within the category of aggrieved person. Only a person who has suffered or suffers from legal injury can challenge the act, action, order, etc. in a court of law. A writ petition under Article 226 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right or when there is a complaint by the appellant that there has been a breach of statutory duty on the part of the authorities. Therefore, there must be a judicially enforceable right available for enforcement on the basis of which writ jurisdiction is resorted to. The court can, of course, enforce the performance of a statutory duty by a public body using its writ jurisdiction at the behest of a person, provided that such person satisfies the court that he has a legal right to insist on such performance. The existence of such right is a condition precedent for invoking the root jurisdiction of the courts. It is implicit in the exercise of such extraordinary jurisdiction that the relief prayed for must be one to enforce a legal right. In fact, the existence of such right is the foundation of the exercise of the said jurisdiction by the court. The legal right that can be enforced must ordinarily be the right of the appellant himself who complains of infraction of such right and approaches the court for relief as regards same. A legal right means an entitlement arising out of legal rules. Thus, it may be defined as an advantage or a benefit conferred upon a person by the rule of law. The expression person aggrieved does not include a person who suffers from a psychological or an imaginary injury. A person aggrieved must therefore necessarily be one whose right or interest has been adversely affected or jeopardized. Then, my lord, 11, 12, my lord, cases are relied on. And kindly come to one's paragraph 13. This court, even as regards the filing of a habeas corpus petition, has explained that the expression next friend means a person who is not a total stranger. Such a petition cannot be filed by one who is a complete stranger to the person who is in alleged illegal custody. This court has consistently cautioned the court against entertaining public interest litigation. Kindly omit that, kindly come to paragraph 17. The summary, in view of the above, the law on this 8 point can be summarized to the effect that a person who raises a grievance must show how he has suffered legal injury. Generally, a stranger having no right whatsoever to any post or property cannot be permitted to intervene in the affairs of others. And my lord, on Locus, my lord, may I show one judgment, my lord, reported in 2013, 5 SCC, page 427. Copy This is, my lord, reported in 2013, volume 5, Supreme Court cases, page 427. Only one paragraph, my lord, paragraph 24. হাতে পিন ফোটার বন্দোবস্ত করে দিয়েছো হাতে লাগলো Kindly come to paragraph 24. The primary purpose of the writ is to protect and establish rights and to impose a corresponding imperative duty existing in law. It is designed to promote justice, exhibitio justice, and its grant or refusal is at the discretion of the court. The writ cannot be granted unless it is established that there is an existing legal right of the applicant or an existing duty of the respondent. Thus, the writ does not lie to create or establish a legal right, but to enforce one that stood already established. While dealing with a writ petition, the court must exercise discretion, taking into consideration a wide variety of circumstances, inter alia the fact of the case, the exigency that warrant such exercise of discretion, the consequences of grant or refusal of the writ, and the nature and extent of injury that is likely to ensure by such grant or refusal. Hence, discretion must be exercised by the court on ground of public policy, public interest, and public good. The writ is equitable in nature and thus its issuance is governed by equitable principles. Refusal of relief must be for reasons which would lead to injustice. The prime consideration for issuance of the writ is whether or not substantial justice will be promoted. Furthermore, while granting such a writ, the court must make every effort to ensure from the averments of the writ petition whether proper pleading are being made. Further, in order to maintain the writ of mandamus, the first and foremost requirement is that the petition must not be frivolous and it is filed in good faith. Additionally, the applicant must make a demand which is clear, plain, and unambiguous. It must be made by an officer having the requisite authority to perform the act demanded. Furthermore, the authority against whom mandamus is issued should have rejected the demand earlier. Therefore, a demand and its subsequent refusal either by words or by conduct are necessary to satisfy this court that the opposite party is determined to ignore the demand of the applicant with respect to enforcement of his legal right. However, a demand may not be necessary, etc. It's not required. So, my lord, legal right and the pleadings in support there.
Demand and refusal, then invocation of riches.
The first one is, my lord, the legal right, then the pleading, and, my lord, then the demand. My lord, in my submission, the writ petition is devoid of any statement about the legal right of, my lord, whatever, my lord, as I submitted, my lord, the issuance of shares that was on the basis of, my lord, subsequent happening, which was challenged before CLB unsuccessfully. Now, my lord, two more judgments, my lord, on, my lord, the Reserve Bank's, my lord, functioning. My lord, may I first rely on 1986, volume 1, Supreme Court cases, page 264. Kindly come to, I would like to place my 4 or 5 paragraphs. Kindly come to the first paragraph. At page 274 or my lord, page 11.
11?
11 at the top or page 274, my lord, the printed page. if your
Yes,
lord-
274. Yes.
Problems of high finance and broad fiscal policy, which truly are not and cannot be the province of the court for the very simple reason that we lack the necessary expertise, and which, in any case, are none of our business, are sought to be transformed into questions involving broad legal principle in order to make them the concern of the court. Similarly, what may be called the political process of corporate democracy are sought to be subjected to investigation by us by invoking the principle of the rule of law with emphasis on the rule against arbitrary state action. An expose of the fact of the present case will reveal how much legal ingenuity may achieve by way of persuading courts ingeniously to treat the variegated problems of the world of finance as litigable public right questions. Court of justice are well tuned to distress signals against arbitrary action. So corporate giants do not hesitate to rush to us with cries for justice. The courtroom becomes their battleground, and corporate battles are fought under the attractive banner of justice, fair play, and the public interest. We do not deny the right of corporate giants to seek our aid as well as any Lilliputian farm labor or pavement dweller, though we certainly would prefer to devote more of our time and attention to the latter. We recognize that out of the dust of the battle of giants occasionally emerge some new principle worth the while. That is how the law has been progressing until recently, but not so now. Public interest litigations and public assigned litigations are today taking over. Then kindly come to paragraph 34 once. Page 286.
Yes.
Two of the principal questions argued before us were whether the permission contemplated by section 29 was previous permission or whether the permission could be granted ex post facto, and whether the purchase of shares by the foreign investor of Indian nationality origin in this case involved any contravention of FERA or the non-residents investment scheme. To appreciate how the question arises, it is necessary to state here a few facts. Now, well, the facts are stated. Kindly come to paragraph 55 once. Page 308. Page 308. In view of the rejoinder and the concession made before the High Court, in regard to the refusal of the company to register the transfer of shares, the only ground which it is necessary for us to consider is whether the permission granted by the Reserve Bank of India was in order. Escorts Limited having refused permission to register the transfer of shares, one would have thought that it was thereafter up to the purchasers or the sellers of the shares, if they were so minded, to proceed to take further appropriate action in the matter to have the transfer of shares registered. However, it was not they that moved but it was Escorts Limited that filed the writ petition out of which the present appeal arises. They explained that the pressure of circumstances was such that they had no option except to go to court under Article 226 of the Constitution. It appears that on October 18, 1983, Escorts met with the representative of the financial institution ICICI, IFC, IDBI, and UTI. It has to be mentioned here that 30% of the shares of Escort are held by Life Insurance Corporation, 16% by Unit Trust, and 6% by General Insurance Corporation and its subsidiaries. According to Escorts, at this meeting, their representative gave full particulars of various illegalities committed by such and such group of companies in the purchase of shares of Escorts Limited. But they were repeatedly pressed by the representative of the institutions to get their board of directors to reconsider their earlier refusal to register the transfer of shares. It was said that so-and-so, the chairman of the Unit Trust of India, even said that the financial institutions who owned 52% of the shares were in a position to remove the management at will. There were other meetings also with the representative of the financial institutions. Mr. So-and-so, the chairman of Escorts Limited, was requested to meet Mr. So-and-so, chairman of IDBI and a director of life insurance. But kindly omit that, kindly come to my lord directly paragraph 84. Page 326. Paragraph 84. On an overall view of the several statutory provisions and judicial precedents to which we have referred, we find that a shareholder has an undoubted interest in a company, an interest which is represented by his shareholding. Share is movable property with all the attributes of such property. The rights of a shareholder are 1. To elect directors and thus to participate in the management through them. 2. To vote on resolutions at meetings of the company. 3. To enjoy the profits of the company in the shape of dividends. 4. To apply to the court for relief in the case of operation. 5. To apply to the court for relief in the case of mismanagement. 6. To apply to the court for winding up of the company. And 7. To share in the surplus on winding up. A share is transferable, etc. Kindly omit that. Kindly come to the next page. Towards the bottom, my lord, about 10 lines from the bottom of that page. The sentence starting with the provisions of Foreign Exchange Regulation Act. The provisions of the Foreign Exchange Regulation Act are so structured and woven as to make it clear that it is for the Reserve Bank of India alone to consider whether the requirements of the provisions of Foreign Exchange Regulation Act and the various rules, directions, and orders issued from time to time have been fulfilled and whether permission should be granted or not. The consequences of non-compliance with the provisions of the Act and the rules, orders, and directions issued under the Act are mentioned in section 48, 50, 56, and 63 of the Act. There is no provision of the Act which enables an individual or authority functioning outside the Act to determine for his own or its own purpose whether Reserve Bank was right or wrong in granting permission under section 29(1) of the Act. And my lord, last 4 lines of that paragraph. It is necessary to remind ourselves that the permission contemplated by section 29(1) of the Foreign Exchange Regulation Act is neither intended to nor does it impinge in any manner on any legal right of the company or any of its shareholders. Conversely, neither the company nor any of its shareholders is clothed with any special right to question any such permission. In view of, my lord, this, my lord, in my truthful submission, the writ petition was, my lord, not maintainable. It could not give any right even to the company, forgetting about Shojol, to, my lord, challenge the action of Reserve Bank of India. 192 টা দেখো। Lord, one more judgment, 2 paragraphs, my lord. It's reported in 1992, volume 2, Supreme Court cases, page 343. Paragraph 30, kindly come to page 374. Paragraph 30. Page 374. Paragraph 30. Before examining the scope, Lordship's got that.
Yes.
Before examining the scope and effect of the impugned paragraph 6 and 12 of the direction of 1987, it is also important to note that Reserve Bank of India, which is Bankers Bank, is a creature of statute. It has large contingent of expert advice relating to matters affecting the economy of the entire country, and nobody can doubt the bona fide of Reserve Bank of India, Reserve Bank, in issuing the impugned direction of 1987. The Reserve Bank plays an important role in the economy and financial affairs of India, and one of its important functions is to regulate the banking system in the country. It is the duty of Reserve Bank to safeguard the economy and financial stability of the country. Then, my lord, kindly come to paragraph 31, my lord. I kindly come to paragraph 31. The functions of the court is to see that lawful authority is not abused, but not to appropriate to itself the task entrusted to that authority. It is well settled that a public body invested with statutory power must take care not to exceed or abuse its power. It must keep within the limits of the authority committed to it. It must act in good faith and it must act reasonably. Courts are not to interfere with economic policy, which is the function of experts. It is not the function of the courts to sit in judgment over matters of economic policy, and it must necessarily be left to the expert bodies. In such matters, even experts can seriously and doubtlessly differ. Courts cannot be expected to decide them without even the aid of experts. Now, my lord, here, my lord, as my lord, the Supreme Court also, my lord, in the decision I have cited, my lord, between the same parties, has taken note of the fact that, my lord, the machines have been utilized by the company. Entire benefits were taken, and, my lord, when the company, my lord, taking advantage or taking benefit of the machines, had, my lord, started gaining profit, only then, my lord, all these disputes arose between the brothers. Now, coming to the order impugned, my lord, only the maintainability part, my lord, may I show. My lord, it's at page 344, but I think, my lord, I would hand over a legible copy of the order, my lord. Yes. It's at page 344. But so far as my copy is concerned, my lord, it's not very legible.
We seem to be more fortunate than you.
Sorry, ma'am.
We seem to be more fortunate than you.
That's what I told my learned friend. Even I'm more fortunate than
No, it's practically illegible so far as my copy.
Yes.
No, তাহলে তো মুশকিল আমি এবারে পেজ নাম্বার মেলাবো কি করে? Oh, kindly come to page 351, my lord. Slight background and then, my lord, or my lord, page 350. Second paragraph. On 22nd March 1997, Reserve Bank of India granted approval to the company under section 19(1)(d). This I place today. Next paragraph, the relationship between the two brothers. Third paragraph, my lord, at page 350. The
Yes.
relationship between the two brothers started deteriorating very rapidly after the incorporation of the company. It came to a head on 19th April 1995 when a purported resolution was passed to issue and allot not more than 40 lakh equity shares of ₹10 each at per to persons, corporate bodies, banks, mutual funds, financial institutions. Although Kamal Datta was shown to be present in the meeting, he later alleged that the resolution was fabricated at a later date. Subsequent resolutions were passed on 7th February 1996. Kamal was removed as managing director of the company, succeeded by Kamal Malad. This was set aside by the Supreme Court. Therefore, when Reserve Bank of India gave permission on 22nd March 1997 to allot shares to Kamal for importation of second-hand medical equipment, he had ceased to be the managing director of the company and in control of it. Shojul assumed the control of the company and filed a writ application in this court challenging the permission granted by Reserve Bank of India. On 20th May 1998, the permission was withdrawn. This court directed personal hearing to be given to the parties before passing any order. Reserve Bank of India once again endorsed its earlier approval of allotment of shares in favor of Kamal. A second writ followed. Once again, the High Court directed rehearing of the by the Reserve Bank of India. Once again, the bank on 7th May 2004 confirmed its order granting permission to allot shares to Kamal against supply of second-hand medical equipment. The present writ is the third writ. The court directed as an interim order that any allotment of share to Kamal would abide by the result of the writ. It was filed in the year 2004. For 13 years, it is pending. Then, meanwhile, Kamal on or about 12th November 1997 moved the company law board complaining against Shojul that his action was oppressive to him. It inter alia held that the kindly omit that, kindly come to the next page, page 352. The Locus standi point, my lord. Now I come to the law points. After the order of this court made on 30th November 2006, deleting the name of the company from the cause title, Shojul proceeded with the writ as the sole petitioner. At this point of time, he was only a shareholder in the company. In 2007, the respondent number 6 made an application in the writ being GA number 360, wanting dismissal of the writ in the changed circumstances. One of the grounds taken in the application was that Shojul as the shareholder did not have the locus standi to maintain the writ. Then, my lord, cases are referred to. Kindly come to the last paragraph at page 353. The court had to be satisfied about the locus standi of the petitioner before entertaining the writ as held by the said court in such and such. These cases were cited by so and so. Then kindly turn the page. The learned counsel for the writ petitioner submitted that sometimes the shareholders are granted fundamental rights. If those rights are impaired by state action, a writ would lie to remedy the wrong as held by Supreme Court. Now, my lord, pausing here for a moment, in my respectful submission, no right was impaired by the state action. It was only a permission, nothing further. Steps taken pursuant to this permission was challenged unsuccessfully. Now kindly come to page 355. The last paragraph at page 350. Hence, on examination of these authorities, it is plain that a person individually affected by an action of the state or one of its instrumentalities can file an application under Article 226 of the Constitution of India. The injury must be personal. There is no averment to that effect. A company is a juristic entity. It is different from its shareholders. An action of the government or its instrumentality should cause injury to the company for it to found an action under Article 226 of the Constitution of India. Normally, if an act affects the company, a shareholder is not affected. Is not an affected party and does not have the right to challenge the action. He has no locus standi to challenge it. Sometimes the action complained of is such that both the company and the shareholder can assail it, as it affects both of them. In those circumstances, a writ application by a shareholder is maintainable. Look at the situation in this case. At the time of incorporation, Komol had 52% share and Shojol had 48% share. There was a decision by the company to import medical equipment. The equipment actually imported were second-hand. Komol wanted an allotment of shares in his favor for providing the equipment to the company. On 22nd March 1997, necessary permission in this behalf was granted by Reserve Bank of India. Shojol felt aggrieved by grant of this permission because if shares were allotted to Komol, it would further enhance his shareholding. That was challenged separately.
May I have your lordship's leave for a moment?
Shojol, as we all know by now, thought that his brother Komol could not seek permission of Reserve Bank of India to import second-hand machinery on a non-repatriable basis and claim share for it. At one point of time, Reserve Bank of India withdrew the permission it granted. Again on 17th May 2004, it granted it. No matter what may be said, if one shareholder is claiming shares on the basis of importation of second-hand machinery, it is likely to alter the shareholding percentage of other shareholders. Kindly bear this paragraph. No matter what may be said, if one shareholder is claiming shares on the basis of importation of second-hand machinery, it is likely to alter the shareholding percentage of the other shareholder. In this other shareholders, my lord, I pause here for a moment. Kindly take, my lord, a situation where this, my lord, permission was granted, but the company was in control of Shojol. Would he have issued the shares? I could have understood, my lord, that it was a direction from Reserve Bank of India. Yes. Then Shojol was bound, or the company was bound to issue. Shares were not issued until, my lord, the Supreme Court order, by Supreme Court order, my lord, Komol came into power. Komol took control of the company and then shares were issued. Nothing happened till 2006, 2007 in fact. Issue holo kobe 2007, 2006-7 when shares were issued. Supreme Court order is of 2006. If I remember it correctly, shares were issued in 2007. 6 or 7. Till then, nothing was done. Allotment of shares to Komol would have tipped the balance of control of the company in his favor. Allotment of shares, my lord, I was at page 356, second paragraph. Allotment of shares to Komul would have tipped the balance of control of the company in his favor. Therefore, Shajul was likely to be directly affected by the allotment of shares to Komul. Now, my lord, Shajul has taken benefit of, or taken, my lord, has challenged this allotment unsuccessfully. And my lord, interestingly, my lord, in a petition of my lord under section 397 filed by Shajul, the CLB directed Shajul to, my lord, resign from the directorship of the company. Was removed. Yes, was removed. No, CLB last order last part. The last line, last two line. May I read out, my lord, the May I read out this CLB's order, my lord, the last part? That Mr. Shajul Dotto shall be ceased to continue as director of the company after expiry of 60 days from the date of this order is made available on the website of the company law book. And then that the company shall release all the guarantees given by Shajul to the financial institutions. This was done on the company's behalf within 90 days. That if Shajul Dotto 6 exit from the company as shareholder, then the company within 3 months shall take steps. So in his application, he was removed. Then, my lord, coming back to page 356. The last paragraph. In other words, the Reserve Bank of India may have given permission to the company to import medical equipment on its application. It also may have allowed the company to issue shares to Komul on a non-repatriable basis for financing the equipment. Undoubtedly, the company would be affected by any decision of Reserve Bank of India to grant license or revoke it. It is also equally true as held by the Supreme Court in LIC versus Escort that Reserve Bank of India is the sole judge whether the license is to be granted or not, and no other authority can take this burden upon itself. But on examination of the above fact, the license to import was vitally connected with the shareholding of Komul and the percentage shareholding of his brother Shajul. The import took place much earlier. It had got nothing to do with the permission granted by Reserve Bank. If the number of shares issued to Komul increased on the basis of importation of those items, the percentage shareholding of Shajul was likely to fall. Therefore, both the company and its principal shareholder Komul and Shajul had an interest in the grant of license or revocation of it. Now, I'm sorry, my lord, at the risk of repetition, my lord, the permission did not or could not compel the company to issue any share.
Shajul did not issue.
And Shajul did not issue.
The permission was there. There was
Therefore, both the company and its principal shareholders, Shajul and Komul, had an interest in the grant of license or revocation of it by the Reserve Bank of India. As far as the decision of LIC versus Escort is concerned, none doubts the authority of the Reserve Bank of India to grant the license. But it should be remembered that Reserve Bank of India, like other creature of the Constitution and the statute, is amenable to a writ of mandamus, commanding it to do its duty. Now, my lord, I have shown, my lord, what should be done and what the judgment of the Supreme Court. In the two previous writ applications, orders were passed by this court directing Reserve Bank of India to consider the issue of grant of revocation or grant of license upon hearing Komul and Shajul. My lord, those writ petitions were heard when the company was still there as writ petitioner, of which, my lord, Shajul was then in control. Therefore, both the brothers had the right to approach the court complaining of failure on the part of Reserve Bank of India to discharge this duty by refusing to pass an order or by passing a wrong order. Now, my lord, with greatest of respect, my lord, the order impugned does not show or say or indicate as to why the order was wrong.
So is it a fact that issuance of these shares would exceed the 88.88% in
No,
it?
no.
It would be within that.
Absolutely. Absolutely. It has not been crossed even.
No, it would not.
It would not have.
That was the agreed proportion and it would remain intact.
Absolutely.
This was to be issued in lieu of money. They were going to bring in machinery. This is the issue.
And today, my lord, kindly consider machines imported in 1993 4. Nothing remains of these machines. If required, I shall place the other portion of the impugned order, my lord. It's recorded in the Supreme Court order also. Partition. And my lord, to conclude, my lord, I have shown you, your lordships, my lord, the Supreme Court, where, my lord, the Supreme Court has, after taking into consideration this writ petition, my lord, has observed that filing of repeated writ petition, my lord, was an act of oppression on the part of Shachar.
Yes, we have seen the entire order.
My lord, those are my respectful submissions. In my respectful submission, my lord, Shajol does not or did not or does not have any independent right to pursue the writ petition. The writ petition does not indicate any personal cause of action of Shajol. It does not indicate that, my lord, any alleged legal right of Shajol was infringed. Under these circumstances, my lord, the writ petition ought to have been dismissed on the ground of maintainability itself. My lord, I have, my lord, only, my lord, on the
Yes, this was your preliminary on the maintainability.
Yes, I have a cross appeal. That is why, my lord, I took this point.
Subject to your lordships, Mr. Mukherjee has requested if you can respond on the 3rd and 4th of April, your lordships.
Yes, Mr. Mitra.
Any day convenient.
Heard?
Yes, your lordship.
Heard.
Yes, your lordship. Grateful.
he আমার brief কই? ওই আমার
দায়িত্বে নাকি আমরা just an extension.
So this matter last came up before your lawsuits under the heading extension of interim order. When my learned friend, the learned advocate for the respondent, prayed for fixation of the hearing and at 2 p.m. specifically. But I don't find them, my lord, today.
Let us see. We can proceed. They may come because this original side matter was continuing.
That's your
Maybe.
lawsuits.
You were the applicant.
I was before the my lord applicant before the Central Administrative Tribunal. I lost.
Can you give us just a brief bird's eye view of what is the issue
Now, I tell
that
you,
you had
lawsuit,
come to the tribunal with?
now the petitioner my lord, is a degree holder, BTech. He passed the BTech examination.
BTech.
BTech. Now thereafter, my lord, he, my lord, underwent apprentice training. That's, my lord, called CCAA. My lord, the full name will be, your lordships. Just a minute, I give your lordships the full name, CCAA. Course completed act apprentice. Course completed act apprentice.
Act.
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 Malad, this was done by him under the Chittaranjan Locomotive Works and certificate under the direct government of in the railway department. Certificate was issued.
So this is that scheme where they may create a reservoir for
20%. Now, the point, your losses, if it boils down to one, qualification fixed, CCAA must be
completed successfully,
and NAC certificate to be issued by NCVT. That means, your lordships, National Council of Vocational Training. Now, let everybody did their CCAA under the any locomotive works of the under the railway department. But those who had the qualification of ITI, 8 to 10 pass, ITI on Indian,
yes,
ITI, and got CCAA from the any of the railway department's organizations, their certificate was issued by NCVT, National Council for Vocational Training.
Yes.
But what happened in our case, those are degree holder, their CCA certificate issued by the government itself. And they say, therefore, you are not qualified. That's the point.
So your CCA is not issued by the
NCVT. Now, there are several types of training apprentice. Now, my point will be, your losses to show.
So what is the requirement?
Requirement, your lordships,
is issued by NCVT.
NCVT, granted by NCVT.
That is the requirement. Under the scheme.
Under the advertisement, scheme is different. Scheme doesn't say so, my lord.
Where is the advertisement?
And that's right. If your losses straightway come to advertisement, that would be at page. Then I will take your losses to the scheme, all that. I just clause 6 of the advertisement.
Page, please.
I just give you 126. Done. This is the running page of the advertisement. Educational qualification.
Just give us 2 minutes. Educational qualifications. Yes.
Candidates should have requisite minimum educational qualifications indicated for posts in Annexure A of this CEN from recognized board /NCVT/SCVT as on the closing date for online registration. Those awaiting result of the final examination of the prescribed minimum educational qualification should not apply. Then you'll also, there is a note. Diploma/degree engineering will not be accepted in lieu of course completed act apprenticeship/IIT. ITI, sorry, Malad. Also, graduate act apprentice will not be accepted in lieu of course completed act apprenticeship. Now, this has to be read with Annexure A.
Where is Annexure A?
Now, that's page 151. Look at right hand side under the heading minimum educational qualification. 10th pass or ITI from institutions recognized by NCVT/SCVT or equivalent or National Apprenticeship Certificate NAC granted by NCVT.
So Annexure A is, even if we don't go to Annexure A, this is whatever is stated at clause 6 of the advertisement is the same.
Only thing, your lordships, certificate granted by NCVT. Here your lordships will find recognized from board NCVT or SCVT.
SCVT, yes. Here also it says ITF recognized by NCVT, SCVT or equivalent national apprenticeship certificate granted by NCVT.
Minimum educational qualification. My lord, I tell you, lordships, the difference. Here, my lord, 10 pass certificate is never granted by NCVT. This one had to secure from any school, recognized school. My lord, ITI certificate is given by the NAC, NCVT, National Council for Training. My lord, that to obtain that certificate ITI, one has to either 8 pass or 10 pass according to the course he underwent.
So this means ITI after passing 10th.
Exactly. After passing 10. Now, my lord, so far then, my lord, this is not enough. Then your lordships, one has to undergo apprenticeship. Kindly see. 10 pass ITI from institute recognized by National Apprenticeship Certificate or equivalent or National Apprenticeship Certificate. This is all. If I go by annexure, there are 3 disjunctive provisions.
Yes, all right. So these are the qualifications which are referred to in 6.
6. Now, your losses kindly take note of that. Note. Degree, diploma or degree engineering will not be accepted in lieu of course completed act apprenticeship or ITI. Pause here for a moment. My submission is that, therefore, I am a degree holder. My degree is not a bar. What it says? That my apprenticeship certificate, CCAA, will not be in lieu of graduation, that will not be accepted. So I have to secure CCAA. It's not that my higher qualification is a bar. I can't say, look, I am degree holder, therefore CCA is not required. That I cannot say. But simultaneously, they cannot say, you are degree holder, though you CCA, you will not be accepted.
No, it says it will not be accepted in lieu of.
In lieu of. So I have CCA in lieu of. That means I cannot say that I do not have CCA, you accept my degree. That cannot be.
So it does not say in addition to. This is what you are saying.
I have to say exactly. I have to get CCA and I have.
So if I have CCA, even if I have this disqualification, it will not be a disqualification.
This is not a disqualification according to me.
No,
They
it
say
is.
that will not be counted. If your lordship, suppose I have CCA
It says it will not be accepted.
in absence of CCA.
That is how you want us to read. That we have
That's it.
understood. You are saying that once I have the CCA, then even if this disqualification, I have it, it will be immaterial because I possess the requisite qualification. If I don't have CCI and I am a diploma degree in engineering, then I will not be. This
That's
is what
right.
you are saying.
Now I take your lordships to some other documents. One thing I factually tell your lordships, this National Apprenticeship Act underwent a change in major change in at least this sort of matter in 2014. Before 2014, situation was that as we know, someone if gets apprenticeship under the railway, his service was almost secured. If I get an apprenticeship under any public organization, under the Apprenticeship Act, my recruitment absorption was almost secured. Almost. This is obvious that was the situation. Now that provision was amended, Section 22. Now after amendment, the Act provided it is for the employer to frame its own policy.
So in addition to CCA, what is the degree that you are having?
I have the CCA, but not that, your lordships. I take your lordships to the. May I show your lordships my degree? Just for a moment, your lordships must. I should show to your lordships my degree first. So what was I in position apart from my diploma? Your lordships kindly have a look at page 79. This was issued by the Government of India, National Apprenticeship Training Scheme, Ministry of Human Resource Development, Certificate MHRD, commonly we say, Certificate of Proficiency. This is to certify that Moina Goswami, such and such, graduate apprentice has undergone.
So you are having the graduate apprentice.
Graduate apprentice has undergone apprenticeship training under the Apprenticeship Act, as amended under the Chittoranjan Locomotive Works Board.
So you are having the graduate apprentice.
Sir, this is called CCA. This is the certificate issue.
No, just come back to the note at page 126.
Page 126.
Yes. It says, also Graduate Act apprentice will not be accepted in lieu of course.
Also, Graduate Act apprentice will not be accepted
Yes.
in lieu of course completed Act apprentice.
Yes.
This is course completed Act apprentice.
No, it says graduate apprentice.
It says, kindly have a look at this. Moina Goswami, graduate apprentice, has
Correct.
undergone apprenticeship training under the apprentice.
Yes. So you are a graduate apprentice because you have undergone the apprentice.
This is to say that this is the CCAA under the Act. That I will show to your lordships again.
It may be, there are several kinds of CCA, or there is only one kind of CCA.
One kind of CCA. This is issued by this Railway Department Authority.
No, for acquiring a CCAA, there is only one standard, or it can be after 10th as a graduate, after intermediate.
I tell you, lordships, after undergoing training under the Chittoranjan Locomotive Works, those who have passed ITI, they have also undergone the training under the same workshop.
Yes.
but their certificate issued by NCVT, our certificate issued by the government. That's the only difference. Issuing authority are different. I will take your losses. I find some other documents, the IIT, those who are. They have undergone the same training under the Chittaranjan locomotive box.
Yes.
Now, I just tell you losses, then I will take factually. Malad, this is a recruitment process throughout Malad, railway authorities throughout the country. But this advertisement Malad, also includes Malad, Eastern Railway, locomotive authorities and other authorities. Malad, we have shown before lawsuits, I will take your lawsuits, in the previous recruitment process, also in this recruitment process, Malad, in this recruitment process, Southeastern Railway has accepted this candidate. Those who have graduate qualification, engineering, along with this. This under the same ministry. In the earlier recruitment process,
Were you barred from participating in the process?
I beg your pardon.
Were you barred from participating?
Exactly, not participating. Ultimately rejected my candidate.
So therefore, rejected that means on the ground of your certificate, you have not been barred from participating.
Ultimately, they rejected my candidature that this was not granted by NCVT. So that amounts to that. Participation goes from the very beginning.
Where is the rejection?
I showed you lots. Now your lordships, they prepared a page 251. Down. I scored much. Even the host, those who secured in the written examination much less marks.
No, but you were a graduate.
That's
You were a
recent
graduate.
judgment also says higher qualification is not a sin. 10 days before, my lord.
We are not on that. We are saying the advertisement under which you applied, there was a specific, clear and explicit bar. That bar you were suffering because you were a graduate, and after being a graduate, you have acquired the CCA. Now, if they have rejected on that ground, you have participated knowing that this was the ground.
I'm joining an issue. My graduation is not a bar. I would have been barred had I not CCA.
We think that at least based on the qualification that you have shown us, prima facie, we are of the view that because of the fact that you were a graduate.
But that's not the condition. They say diploma or graduate engineering will not be accepted in lieu of CCA.
No, what does it say? You read again.
Page 1
does not say graduate engineering. It says graduate act apprentice will not. So if you are a graduate and then you become an apprentice, then not. It does not say the graduate degree will not.
I tell you, Locus,
Please read again.
Also, graduate act apprenticeship will not
correct.
be accepted.
And this is exactly what your certificate says, graduate apprentice.
Has undergone apprenticeship training under the apprenticeship.
Correct.
But if I undergone any training under the apprenticeship, that is called CCA.
Let's see, where is the rejection?
Rejection, I said. Malad, your losses will find 251.
Yes.
Document verification for PWBD, non-PWBD candidates.
Tenth class also. CCA can be acquired.
Now your losses will find page 251. 251. Yeah, this is cancellation of candidature. My serial number, your losses will be at page 253, page serial number 46. Rejected in terms of clause 12.1. I have not yet placed before your losses 12.1. I will place it. And note below clause 60 of notification CEN of 2019. 12 year losses will get it at page 134. The vacancies, that means 20% vacancies is up for apprenticeship. Vacancies to be filled from amongst the course completed act apprentices trained in railway establishments. But I am in railway establishment. Possessing national apprentice certificate. I am possessing that. But granted by National Council of Vocational Training. This is not granted. My certificate was not granted by. And then 6 your losses. Already, page 126. Note. Now, I take your losses, the other one, my lord, page, the policy before that, your losses will get it after the amendment of the act, page 106. Lord, may I just play? This is of 2016. Pursuant to amendment to section 22, subsection 1 of the Apprentices Act 1951, Board had constituted a committee to formulate the policy for according preference to course completed act apprentices in recruitment. The committee has given its recommendation and accordingly, it has been decided by the board that 20% of the vacancies in case of direct recruitment to post or categories in pay band number such and such, having grade pay such and such, shall be filled. Kindly see your lordships, giving preference to course completed act apprentices trained in railway establishment and possessing national apprentice certificate granted by vocational training. This is the rules, clause 6 of the advertisement is at variance with the policy of the government. Why I'm saying it, your lordships? Kindly see, in respect of filling up of 20% vacancies, only preference to be given. Nothing else, my lord. Because earlier, my lord, act, scheme of the act was changed, that apprenticeship means almost you will get a job. Here only preference will be given to course completed act apprentice. Now, my lord, say why. Suppose, my lord, one got CCAA with graduate like me, and another after ITI CCAA. Now, both are, my lord, if qualified to be considered. Now, my lord, preference can be given to CCAA candidates only if the other things are equal. Well, suppose your lordships against 20% vacancies. This is for CCA, but it presupposes that the other candidates can also be entitled. It doesn't, my lord, create any bar for graduate, non-graduate, nothing. Only, my lord, says CCAA. But therefore, this is at variance. My lord, this is well settled by the courts of law. The preference means when everything is equal between two, then preference will be given. Now, I will show your lordships, even after giving weightage to those candidates, they had secured lesser marks than me.
He is saying that you have got lesser, that is not a ground for rejecting your claim.
No, I have taken,
Performance is not the issue. The issue is whether you suffer the disqualification or not. That's all.
that's, my lord, only their aspect, your lordships.
That
Only
is the only aspect. That's the ground on which it has been rejected.
my lord, that's, my lord, I can, my lord, but I can be permitted to assail the grounds on which this was rejected. I may also be permitted that look from the other angle I am entitled to.
We don't know. Those issues are nowhere.
Yes, my lord, in the application, original application also.
You may be, but there is no basis for saying all this.
Documents.
Had you been given the respective inter se marks of all these
Yes. I have given. Even if I, your lordships, I will go to the extent rules of the games was changed because weightage was given.
Rules of the game, whether weightage, it is not in accordance with this policy. All these things, the issue is only the rejection is on two grounds. Those are the only two grounds that we are required to see, whether note 6 or 12.1. This can be created as a bar to your candidature or not. That's
Now,
all.
suppose your lordships, my lord, if it
There
is
no
not a
question
bar.
of going into, we are not an appellate forum that will re-examine the entire performance and criteria.
No, I'm never said that.
So it is only a judicial review whether the reason assigned is sustainable with reference to the rule and advertisement. That's all.
My lord, that's your lordship.
There's nothing more, there's nothing less.
My lord,
Yes.
if your lordship, we go by the policy.
Yes.
This is the
that
basic.
you have seen. Yeah, that you have shown 21/6/2016.
So, my lord, only the preference.
Yes.
Now, the other, I will, my lord, I jotting down the points, then I will take your lordships to the documents.
Yes.
The other point, your lordships, 20% vacancies were reserved. Now, 20% vacancy, my lord, coming to 2000 and odd. I will give you, lordship, the exact number, the number of vacancies. Only 1,500 candidates, my lord, got job, and the rest not. Rule provides that if you cannot get CCAA candidates, then this will go to the general candidates. Now, my point is that I may not be ITI passed. I am graduate with CCAA. There are more than 500 vacancies. How could you reject my candidature on that when I'm absolutely an apprentice? This is a reserve for apprenticeship candidates. This should not be converted into general categories.
If it is in the advertisement, they can do it.
No,
if it is in the advertisement, then the law is very settled. Then they can do it.
They can do it, but there are conditions when. If you
so
do not,
let us see where is the requirement, any condition imposed by the advertisement that it will be done under such circumstance only.
Before that, I take your lordships to the one order of this tribunal passed in earlier writ petition of the petitioners. I just take your lordships to that. Your lordships will find at page 160.
So twice you have approached the tribunal?
Yes, your lordships.
Why did you appear?
First directed to consider my representation.
What representation?
The representation was that I will take your losses to that also. If losses one by one, and then by this application, the order tribunal allowed my application. Rather directed consideration of my granting.
That is why not?
No, that's your losses, giving that I am qualified.
Finding that you are qualified.
That's your
Let
losses.
us see that finding.
That's your losses. Kindly.
Yes.
Page 161. Kindly see paragraph 4. Since respondent numbers 1 and 2 are not the necessary parties, respondents are permitted to make necessary correction of them. Now, kindly see my prayer. What was my prayer in the original application? OA has been preferred by the applicants to seek the following reliefs. Seeking an order dated such and issued by the principal chief personnel, such and such cannot be sustained in the law and therefore said may be quashed. Then declaration that RB 20 is not applicable in respect of the applicant since the said circular was issued after commencement of training. An order to issue directed to engage the applicants in Group C post CLW since 2015. Leave may be granted. Now, your lordships, kindly see, my lord, paragraph 6. One of the applicant insists and is allowed to appear in person. That's all, my lord. Learned counsel for the respondents, however, assures that the applicant shall be allowed to participate in the ongoing selection process in the event the said process is not yet over. Preference will be given to course completed act apprenticeship over graduate apprenticeships under such rules.
As per the rules.
As per rules.
Yes.
At this juncture, the applicant appearing in person submits that the selection of the examination is being conducted in phases. The last phase is still not conducted, and out of 26 applicants, 16 had applied against selection process. They have also been issued admit cards to sit for the examination, but they fear total exclusion of CCAA are given preference. The analogy is not comprehensible as to why matriculate CCAA would be preferred over graduate apprentice when both have been evidently trained in railway organization.
This is the submission being recorded.
I'm
not the tribunal's finding.
This is not, analogy is not comprehensible. Respond.
This is your submission before the tribunal. This is
Not,
not the finding.
not our submission.
Oh yes, from para 8 is the submission being recorded.
Para 8 is the submission.
From para 8 is the submission,
Now,
not just para 8.
Kindly, Your Lordship, para 10.
Yes.
In view of the fact that the minimum requirement is that of matriculation and course completed act apprentice certificate, and that course completed act apprenticeship may get preference over others in the selection process, the applicants graduate apprentices are well within the right to participate in the selection process and being considered. And somebody has been allowed all, and somebody has been selected by the other railways.
Maybe we don't know what were their qualifications.
That's the same qualification.
We don't know. They are not.
That I will try to show your losses. Then your losses, kindly see. Therefore, such applicants who have applied shall be allowed to participate in the examination.
You are which number applicant in this way?
This I just first one, my lord. I appeared in person.
Yes.
Moina question.
Very good.
This was, my lord, not questioned before any of the authorities.
Yes.
Now I take your lordships to the original application. Then I will take up your lordships to the this writ petition before your lordships.
And you have in your present OA, you have disclosed the earlier OA also.
I beg your lordships.
In the present OA, you have disclosed about the order passed in the earlier OA also.
Yes, yes, yes. Now, I take your lordships to the paragraphs Now, your lordships, my lord, kindly consider that running page 60. Paragraph Roman 16. That's the policy of the government at page of 2016 that I have shown to your lordships. Then government issued another circular. Your lordships will find it at page That's annexure. At page, my lord, 108, which has been referred to page 60, paragraph Roman 17. Your lordship, kindly have a look at page 108. This is after 2016, 2017.
Whatever is explicit from the advertisement will prevail. There may be 100 policy decisions taken prior thereto. When a process is initiated for filling up a vacancy, a particular modus is already decided, explicitly stated in the advertisement, you apply in terms of that advertisement, then where's the question of going into history? It will be guided by the advertisement. The law is very well settled.
My lord, no doubt that, but your lordship, one issue I can join. Suppose an advertisement, my lord, contains a provision which is contrary to rules.
Then
rules
you could have objected that don't proceed with this advertisement. I will not participate. You don't proceed. That option was available.
That's demurrer point, your lordship.
Huh?
That demurrer point, your lordship.
That's not an issue of demurrer. That is, you are looking it obviously from your client's perspective, but there is a process involving thousands of candidates. For your oversight or your casual approach or your omission to assail, should everyone suffer?
No, I have not suffered. Everybody, IIT candidates all have been
Therefore, we have to proceed as per the advertisement. There is no question of adding, subtracting, or reading anything into that.
My humble submission, your lordships.
Yes.
As your lordship says, that's the law, go by the advertisement.
Yes.
But if it is contrary to rules, rules will prevail.
So which rule?
Here, your lordship, policy decision of the government partakes the character of rule.
All right.
That's my point, your lordship. Because this generates from that.
A rule always has to be a rule issued under the proviso to Article 309 of the Constitution of India. Rule, what is a rule is well settled, sir. Therefore, these letters issued by the Railway Board and these several circulars or from time to time unique policy decisions taken, they will not become a rule under the proviso to Article 300.
To this
they
extent,
will not assume the character of a statutory rule. These are internal correspondences, whatever you have shown till now.
This is not internal.
Letters.
No, this is the policy decision of the government.
These
this
are
is from the Ministry of Railway.
That's what we are saying.
Basis, they kept 20% reservation.
Maybe, but there's no rule. There is no violation of any rule.
All that I'm trying to submit.
What is the rule is now by now well settled and established.
Suppose your lordship, in absence of rules, government can issue executive instructions. That's also under
in absence of it can be done.
So, my lord, if we read it, this is the executive instruction of the government.
We are not. We don't think that it can be enlarged to that extent. Now you cannot be permitted to invoke or revoke or look into issues which were arising 2 years prior to issuance of the advertisement and say, why did you not consider this? Why did you not consider this? There is a very explicit advertisement, elaborate advertisement, which you read, you say, I qualify as per this. At the same time, you say the advertisement is not in accordance. Both things you are saying.
Not in accordance, no. Only that this should be NCVT. That's your lordship.
Your initial thing is in lieu of. Therefore, I can be accepted.
Graduate.
So that is on the one extreme of the pendulum. The other extreme is that they cannot demand this.
Demand this only, Malad. They cannot say that I will.
The two are mutually, they are not mutually,
not exclusive.
Yes, they are mutually exclusive.
Probably I have been misunderstood by your lordship. What I am trying to say, your lordships, if I have a CCAA,
that you have said, you have a CCA requirement.
So therefore,
CCA.
Nothing is more is required.
Correct. That is your case. So whether the advertisement sustains this submission or not, that is all. Why to go into the last policy and earlier policy?
I have to show to your lordship because how it is generated.
We are only going to see whether the tribunal has committed an error. We are not here to examine the thing in this level, at this level. You realize the jurisdiction which you are at. We are not before the tribunal.
No,
the tribunal has seen everything. We have gone to the advertisement to see whether the conclusion is sustainable or not. So that is all.
Now,
No
before
question
you,
of looking into earlier policy.
the other facts I just tell your lordships, then I will take your lordships to the page 61. This was also, my lord, a case before the tribunal, but that has not been considered, according to me, my lord. Paragraph 21. Lord, here lordships will find that this vacancy 29 of 2019, my lord, consisted of 1,03,769 posts. Out of that, my lord, 20,374, which amounts to 20%, was reserved for apprentice CCA candidates.
Yes.
That's your lordship, paragraph 21, page 61.
Yes.
Now your lordships will find.
And you applied for which post?
Well, it's all now say group C, so group D post, all group D, level 1. Now this is called group C.
Let us see the central employment notice first.
Exactly, loss. I take your losses to that. Well, that starts at page 118. Level 1, your losses will find. Level 1 of 7th CPC. That's the post. This is group D post. Now this is called group C. Now your losses kindly see all the railways, my lord. 16 railways are covered by this notification.
Show it from the.
that clause that should be transferred.
Yes.
Just a minute. আচ্ছা ওই ক্লজটা কোথায় ট্রান্সফার করে দেব জাস্ট a minute. দাঁড়ান আমি দেখেছি your losses will find 12.1 itself, page 134. I have placed before losses first 3 lines. Let me place it entirety. At page 134, 12.1, the vacancies to be filled amongst the course completed act apprentice trained in railway establishments and possessing National Apprenticeship Certificate granted by National Council for Vocational Training is separately indicated in the vacancy table. This will be in the nature of horizontal reservation as in the case of persons with benchmark disabilities, PWBDS and ex-servicemen. However, unlike in the case of PWBDS, there will be no carry forward of the unfilled vacancies to be filled by this mechanism. In case of shortfall, the
In
vacant
fact, it
slot,
says there will be no carry forward.
no carry forward.
Yes.
What they says, the formula, this will not be carried forward for the next.
Correct.
This 20%. In
will be-
case of shortfall, the vacant slots shall be filled from others in the combined merit list.
Correct.
What I will, the facts I'm all trying to say, your losses, suppose I have shown you losses 20,000 vacancies for the 20%. Apprenticeship training, CCA, that's the paragraph I have said to your losses. Now 15,000 filled in, I have shown you, so to your losses.
Yes.
Now the rest 5,000 or whatever maybe the vacancies remain. Now, my lord, who are the apprentice CCA certificate holder from the railway establishment? They should be preferred first. Why those vacancies should be filled up from the others?
Which others?
My lord, that's also the combined merit list. That goes from the combined merit list.
How, whether it will, how it will improve your, sir, it will not improve your chance.
Yes, my lord, immediately I will get it. Immediately, I will show to you, immediately I will get it. Because the first they have taken your losses only ITI CCAA,
Yes.
except few according to their choice, like myself.
Yes.
The rest vacancies are all of the candidates like me.
No, but then those who are qualified only can be considered. Those who are not qualified, how can they be considered? Maybe lesser in merit, but those who are possessing the educational requisite qualification, only those can be considered. If a
your
situation,
lordship goes against me that I am totally disqualified,
No.
then it's different.
what is their reason is that you are not qualified.
That's your loss.
So therefore, unless we come to a conclusion that you are qualified,
Exactly.
there
Otherwise,
may be
I don't- I don't
there
know.
may be 10,000 vacancies.
But that's I'm
So-
trying to decide, making these submissions. If I'm qualified,
Correct.
then my lord, this
So
vacancy
therefore,
should
we
be.
first we have to see whether you are qualified or not. Then only we will see whether there is any vacancy remaining or not remaining.
All right, my lord, I will try my
There-
best that I'm qualified.
We are trying to ascertain how you are to be treated as qualified. That is the thing. Then we'll go to the other issue. We'll continue tomorrow. Yes.
But kindly do not take it up tomorrow, my lord, please, at least.
No, though so much of time as we want to complete it. Let's do it tomorrow morning, afternoon, whatever time suits you. You tell us.
Well, at least on a Thursday.
Please. don't-
Your losses tomorrow has been fixed matter that Mr. Mukherjee is arguing. That's college matter, Rani Birla.
Tomorrow. What is fixed tomorrow?
Kindly give me